Blessings to all. I want to acknowledge the many people to whom I have plagiarized from, I mean to say, have done extensive research to bring you this information. I am not a lawyer, attorney, paralegal, politician or anyone taught to deceive, mislead, or confuse. Luke 11:52, Woe unto you, lawyers! For ye have taken away the key of knowledge, ye entered not in yourselves, and them that were entering in ye hindered. I offer no legal advice and offer my interpretation of what I have heard, seen, experienced, understand and or believe. I have reached my conclusions, feel free to do the same. I have not been paid for the creation, sharing, or distribution of this book, and I freely give this information out to others, without recourse and without prejudice. This book is valued at 14 trillion.00, 14 trillion and no cents, to be paid to the U.S. Treasury, for it is their scriptures I talk about. I am one of the people. The Constitution for the United States of America Amendment 9, the enumeration in the Constitution, of certain rights, shall not be construed to deny or disparage others retained by the people. Amendment X, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. In America, we have no king but God. Declaration of Independence, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it. I do not consent of being governed by anyone but my God. Men are a poor substitute for the Almighty. I reserve all my God-given rights and immunities. I waive all benefits and privileges. I give this to my brothers, sisters, mothers, fathers, loved ones, and enemies, to anyone with ears to hear, eyes to see and a heart to love. For those that feel more comfortable with titles, I am Reverend Douglas Riddle, D.D., Doctor of Divinity. Douglas Riddle, MBA. Douglas Riddle, author, writer, thinker, doer, helper, genius, and / or supporter. Douglas Riddle, occupant of the office of the executor of the Douglas Riddle estate. Douglas Riddle, grantor, grantee, beneficiary, trustee, truster, settler, servant, master, slave, wealthy, poor, judge, jury, benefactor, creator, and / or destroyer. Ambassador to the kingdom of heaven, with full power of attorney from Jesus Christ, King of the kingdom of heaven. You just have to ask me which hat I am wearing and present your reason and authority for wanting to know. At a moment's notice, I could change my title for whichever does me the most good. I pledge my allegiance to God. I live in peace when allowed to. I do not intend to harm anybody, or fiction. It is not my place to destroy or want to destroy, even those elements of a satanic government. Matthew 5:25-26, agree with thine adversary quickly, while thou art in the way with him, lest at any time, the adversary delivers thee to the judge, and the judge delivers thee to the officer, and thou be cast into prison. Verily I say unto thee, thou shalt by no means come out thence, till thou hast paid the uttermost farthing. I love, I hate, and I hold onto, I release, I blame, I forgive, and I am a child of the universe, as is anyone who reads this. Feel free to disagree. 2. Index. Blessings to all. 2 Index. 3 Accepted for value. 4 Spells. 4 Federal Reserve Notes. 4 Law of Nations. 5 Corporate America. 5 Authority of the coin. 5 Oaths. 6 Power and authority is in the people. 7 False coiners. 7 The gold ends here. 9 Government obligations discharged. 10 14th Amendment. 11 In God, government obligated discharge, we trust. 12 Trust. 13 Settler. 15 Authorized liability. 16 forbidden gold, 16 payback, 17 value, 18 bank, 19 internal revenue, 19 voucher, 22 worthless, 23 claims and accounts, 24 give permission, 25 commerce, 26 as old as time, 27 tender, 28 sinful, 29 conclusion, 29 memorandum of law, 30. 3. Accepted for value. What is accepted for value? Is accepted for value a valid process? While there are variations of the words and the magic that happens, as indicated by parenthesis, it has been generally noted that the language at a 45 degrees angle goes something like accept, for value, return for value, for settlement and closure, and exempt from levy. By one would then holograph autograph, sign it, aka wet ink signature, creditor, republic, man on the land, and below would place, authorized representative, exemption identification number, social security without dashes, and date it. For deposit to the United States Treasury and charge the same to the vessel of the United States, the all-capital name, your name in all capital letters, the debtor, democracy, citizen of District of Columbia, and the number assigned to it, tax identification number aka social security number with dashes. Generally, two colors are used, red, and blue. All of the above in red and sign in blue or reverse them. Then an order for money is created, or a money order. This is done horizontally. Money order, pay to the U.S. Treasury, some claim the company. Then just like a check, $10.01, an example number amount, 10 and 01/$100, $10.01. Holograph autograph, signature, authorized representative, and exemption identification number. Then like a check to you, you would endorse the back of the money order, some add without recourse. Spells. Why do I cast a spell with E? Endorse. Common language is endorse, UCC language is endorse. There is a reason for altering the way one casts a spell on paper. When you do talk or write, you are casting a spell. Why do they call it spelling? Proper spells gains control over the object, they can be a blessing or a curse, spell, cursive. We use our God-given ability to move a mountain into the sea, to make blocks, barriers, fear, hate, apathy, judgment and failures and wonder, why these things happen to us. Use your God-give powers for love, forgiveness, enthusiasm, and courage. Again, write in red and sign in blue. However, some have done this in a variety of colors, wrote it in red, blue and even black. However, the holograph autograph should be in blue, or red. Why blue or red? Blue is rumored to be blue blood, royalty, and money. Red is common man, blood, creativity. You do not believe words are spells, ask for something, and say please. Now let us look at money. Federal Reserve notes. Are Federal Reserve notes real monies? Is this all there is? This is actually just beginning, as the beast is huge, it has to be, as it is all a lie. Truth is, money does not exist. Debts exists, credits exists, however, money, currency, has never existed in God's kingdom, only in the man-made governments. Even though money has been accepted as real, with the Federal Reserve note as the dominant currency, there are several alternatives. I live in a world without money. As do you. The difference is, I am aware of this fact. Can you believe that this world without money exists? Are the Federal Reserve System and the democracy considered false coiners? The fraud and deception is so huge, you can begin almost anywhere, cover all the known bases and still discover a lot more. People have sought out the truth at the expense of their well-being in order that we can benefit from their discovery. Blessed be the unknown men, women that have suffered, and the names of the men and women that we do know, which have helped bring this information out. You shall know the truth, and the truth shall make you free. John 8:32. Clear your head, and with our eyes open wide, we begin. God guide us in this journey of truth and knowledge. Let us look at what we think is the way our money system is, i.e. U.S. currency. U.S. currency is money the government creates. It has a purity requirement, weight requirement, and a value associated with it. U.S. Constitution Article 185, to coin money, regulate the value thereof, and of foreign coin, and fix the standard of weights and measures. Where did this value for money come from? It is arbitrary, they make up the value. 1 ounce of silver can be any value or the government, decides it to be, agreed to, or accepted for. Therefore, in reality it means nothing, other than, this is a U.S. currency standard. The government places a specific value on the coins it mints. We also have gold, or silver, certificates, i.e. paper U.S. currency, mostly gone, or found with collectors. We have seen the authority to mint coins. What do we use it for? The Constitution for the United States of America Article 110, no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. Only gold or silver is used to pay debts. Who gave them this power? How? We, the people, have the power to create, and delegate our authority to the government. Unless you believe the created can decide what authority they have. As a creation of God, I would not accept this satanic belief. The hierarchy goes, God, people, and angels. We lawfully operate, God, priests, people, government, and corporations. We legally operate, corporations, government, and people, and excommunicate God. Even wonder how God's chosen people will be deceived. They do not want to learn or cannot believe the truth. I would rather be called a lunatic than miss the boat to paradise. 4. Law of Nations. The Common Law of Nations, LAN, is an international agreement. In fact, this is LAN, Law of Nations, claim, these of the utmost practical importance to the well-being, happiness, and ultimate and permanent advantage and benefit of all mankind, and, therefore, ought to be studied by every gentleman of liberal education, and by youth, in whom the best moral principles should be inculcated. Yet, today we hear nothing about the law in our schools. The law also has strict methods regarding money. This is a major reason why we can no longer be a nation but a corporation, posing as a government, a republic. When in fact, it is a democracy, a corporation, as we no longer follow the law. We begin in Law Book 1 Chapter X 105, Establishment of Money. In the first ages, after the introduction of private property, people exchanged their superfluous commodities and effects for those they wanted. Afterwards gold and silver became the common standard of the value of all things, and to prevent the people from being cheated, the mode was introduced of stamping pieces of gold and silver in the name of the state, with the figure of the prince, or some other impression, as the seal and pledge of their value. This institution is of great use and infinite convenience. It is easy to see how much it facilitates commerce. Nations or sovereigns cannot therefore bestow too much attention on an affair of such importance. Today, around the world, money is created by false coiners. Corporate America. Some of you might think the government is not a corporation. Below is a list and you ask yourself, then why did they file as a corporation? Feel free to check them out. Also, find out when they did this. This is not all of them, a small list, to illustrate a point. Are governments, corporations? Are corporations, governments? If a corporation were a government or government corporation, then a citizen of the government would have to be an employee of the corporation. Can you be a citizen of Walmart? Can Walmart arrest you? Can Walmart send you to death row? Could Walmart create your birth certificate, marriage license, driver's license, SS card, etc.? Just place the authority in your bylaws and create a subcorporation to do it. United Nations Order World Administration Delaware Corporation File #094-2563. The United States is a corporation, a legal fiction that existed well before the Revolutionary War. Republic of Sweden, 1 Dallas 43. United States of America Nonprofit Organization Number 2,193,946. United States Code Title 28, Part 6, Chapter 176, Subchapter A, 3002, 15, United States means, a federal corporation. Federal Reserve Association Nonprofit Religious Corporation #00422817. Internal Revenue Tax and Audit Service, Inc. Domestic General Corporation #0325720. Social Security Corporation For-Profit Corporation Number 2,213,135. Internal Revenue Service Representation Incorporated Number 2,934,047. Central Intelligence Authority, Inc. CIA For-Profit Delaware Corporation 200-4409. Prentice Hall Corporation System Incorporated Foreign Business Corporation Number 623,745. Central Oregon Bar Association, Inc. State of Oregon 098774-16. Oregon Chapter of the Federal Bar Association Domestic Nonprofit Corporation #350,083-90. Oregon Chapter, National Bar Association Domestic Nonprofit Corporation #272,940-99. United States of America vs. National Trust Co. of Washington Domestic Nonprofit Corporation #011855. United States Corp Co. Private Placement for State of Oregon For Profit Oregon Corporation Foreign Business #005316240053116-24. Union Bar Attorney's Office or Agent, Closed Shop for the Prentice Hall Corp System Incorporated Private Corporation #0053116-24. Oregon Bar Association State of Oregon Corporation Domestic Nonprofit Corporation #525,465-96. Oregon Chapter of the National Bar Association State of Oregon Corporation Domestic Nonprofit Corporation #575,397-86. Southern Oregon Federal Bar Association Domestic Nonprofit Corporation #656,907-87. Oaths. Oaths of Office. The Constitution for the United States of America. O. Article 6(1) Clause 3. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation, to support this Constitution. I ask, have they done so? O. Article 2(1) Clause 8. I do solemnly swear, or affirm, that I will faithfully execute the office of President of the United States, and will to the best of my ability, preserve, protect and defend the Constitution of the United States. Title 5. O. 3331. Oath of office. An individual, except the President, elected or appointed to an office of honor or profit in the civil service or uniformed services, shall take the following oath. I, do solemnly swear, or affirm, that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear 5. True faith and allegiance to the same, that I take this obligation freely, without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. Oh. Judges have the Title V Oath of Office. Oh. Another one for judges found in Title 28, 453 says each justice or judge of the United States shall take the following oath or affirmation before performing the duties of his office. I, name, do solemnly swear, or affirm, that I will administer justice without respect to persons, and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as officer under the Constitution and laws of the United States. So help me God. Government officials are to swear these oaths, people are not. Their duties include a. Protecting God-given rights of the people. a. Serving the people. a. Establishing freedom. Warlock. a. Oath breaker. a. Traitor. a. Scoundrel. a. Monster. a. Liar. a. Enemy. a. To lie. Power and authority is in the people. Furthermore, all power is in the people. The Constitution for the United States of America Amendment 9, the enumeration in the Constitution, of certain rights, shall not be construed to deny or disparage others retained by the people. Amendment X, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. We have no king. Declaration of Independence, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to ensure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it. We determine the value of everything, we allow public servants to set a standards, especially when dealing with foreign countries. In this country, United States of America, we, the people, are sovereigns. Sovereignty itself remains with the people, by whom and for whom all government exists and acts. Yquo v. Hopkins, 118 U.S. 356, 370. Will v. Michigan Department of State Police, 491 U.S. 58. The people of the state, as the successors of its former sovereign, are entitled to all the rights which formerly belonged to the king by his own prerogative. Lansing v. Smith, 4 Wendell 9, New York. It will be admitted on all hands that with the exception of the powers granted to the states and the federal government through the constitutions, the people of the several states are unconditionally sovereign within their respective states. 16 How 416, 14 L. ed. 997. One is free to dishonor the court's decisions or deny their existence, then never say anything about Romans 13:1 or 13:7. If we are to honor our government, then we must honor the court's decisions, then we must realize, in the Republic United States of America, we, the people, should they choose, are, in fact, sovereign. In this country, we, the people, are Caesar. In the democracy, we are U.S. citizens. What would happen if people became aware they are sovereign? What would the people do if they studied the law? Is this why we are not being taught the law? People in this country are considered sovereigns without subjects, and we, the people, have the right to coin money. Except, if we do, as others have, they will often be arrested. However, this is because they call it a dollar, a term reserved to the Republic States of the Union. Therefore, we should call it 1 troy ounce, 0.99999% pure, or some designation such as that, and therefore used for exchanges. False coiners. This government cannot be following the law, and this government is nothing more than a corporate bully, as they allow the Federal Reserve to counterfeit money of another nation, America. Law Book 1 Chapter X 108, How one nation may injure another in the article of coin, from the principles just laid down, it is easy to conclude that if one nation counterfeits the money of another, or if she allows and protects false coiners who presume to do it, she does that nation an injury. However, commonly criminals of this class find no protection anywhere, all princes being equally interested in exterminating them. 6. Then again, the Federal Reserve System is not a country, is not a member of any country, and yet it still robs the people, by creating false coins. They are not a state, as state is also a designation for a country or land. A man's home is his castle, and sovereign is a landowner. The Constitution clearly reflects this. No state shall make anything but gold and silver coin a tender in payment of debts. Therefore, here, in the USA, we need not the Federal Reserve, as long as the people create tender out of gold, or silver, when paying debts owed to the government, as that is the only form to pay debts the government can accept. Definition: accept, to receive with approval or satisfaction, to receive with intent. Black's Law Dictionary. 4th. We, the people, as individuals, are not a country, nor could we be with a common currency. Even if we were to coin our own money, as each of us, the people, are sovereign. We could create bonds. This would be circulating foreign commercial paper. Why is this important to understand? Besides not having lawful money, gold or silver, it infringes on our right to contract, and pay debts to the government, and government-created entities, everything that exists on paper. If our contracts use the symbol of dollar, or the word pay in the contracts, or anything that reflects dollars to the government, then it reflects gold or silver currency for the debt, lawful money, reflecting the gold and silver clause in the Constitution. If you use anything other than gold or silver to pay a debt in any connection to the government-created accounts, or numbers, then contractually, it is invalid. You are in dishonor, breach of contract, lied, committed fraud, support rebellion, or simply, you are an enemy of the Republic. Is FRNs legal tender? Yes. Nevertheless, some would have an opposing point of view. So let us look at the opposing view first. This is the Federal Reserve Act of 1913 under 18 of the Federal Reserve Act, 38 Stat. 268, 269, the various Federal Reserve banks could issue circulating notes of the same tenor and under nearly identical terms and conditions as the circulating notes of the national banks. Copy. This is an example of Federal Reserve Bank note. A national currency note. Issued pursuant 18 of the Federal Reserve Act. It states on the top, national currency signed by the Comptroller and Governor, I assume of the Federal Reserve Bank of St. Louis. It also states will pay to the bearer on demand. Now we have Federal Reserve notes that do not have the same verbiage but claims to be legal tender. Can a note be legal tender? If I give you a note, also known as a promissory note, is it legal tender? What if I were to write on the note, good for all debts public and private? The Federal Reserve Bank issues the above, and it was lawful money. Now we have legal tender issued by the Federal Reserve System. Where is this authorized? I cannot find it. If you find it, share it. In 1982 Congress recodified Title 31, Money and Finance by way of a statute known as PL 97-258, 96 Stat 877. In that statute the legal tender status of United States coins and currencies was reassigned, at 5103. Legal tender United States coins and currency, including Federal Reserve notes and circulating notes of Federal Reserve banks and national banks, are legal tender for all debts. Where is the Federal Reserve System? Foreign gold or silver coins are not legal tender for debts. Why is any gold not legal tender? Because it is lawful money. Lawful money, credit instruments, cannot commingle with debt instruments, Federal Reserve notes. Would you put accounts receivable and accounts payable in the same place? As the Federal Reserve System is not a part of the government and is a private corporation, foreign gold and silver would include United States silver and gold coins and all that is built upon it. This also means that FRNs are not U.S. currency, as this statute includes FRNs as a part of the legal tender, thus indicating they are different species. Now, foreign coins are not legal tender for debts, but they could be lawful money, if it is made of, or backed by gold or silver. It does not mean that lawful foreign coins cannot be used for debts, it just kind of puts us in a situation we can only use FRNs, foreign tender, for debts. You have a cloud over the title of everything you purchase with FRNs, because you did not pay for it. Recall U.S. Constitution, Article 110, no state shall pass any law impairing the obligation of contracts. Contracts demand the use of dollar, U.S. currency, or pay, that is to say, gold and/or silver. So the question, is there a law that changed that? Where did the law come from? What changed that requirement? Is it legal? We have seen the U.S. Constitution claims debts must be paid in gold or silver, for all debts. No statute can abrogate the constitutional requirement of the use of gold and silver to pay debts, in the Republican form of government. This changed in 1933 in Congress, an act of rebellion against these United States of America. However, this is not so in the democracy. This is a bankrupt corporation impersonating a government, in an act of rebellion and in agreement with the 14th. 7. Amendment. Why bankrupt? The corporate democracy, U.S., of which has no credit instruments, gold and/or silver, just debt instruments. If all I have are debts and cannot pay them, what actions would I take other than bankruptcy? Yet, in all of this it also claims and circulating notes, below in HJR 192. Regardless, it is not lawful currency, it might be legal tender. States can coin their own money, at any time. People can also, however, do not call them a dollar. Call it 999.999% silver, 1 ounce, but never a dollar. Dollar is a U.S. term and value. You cannot give it a name similar to any country. Name it your last name, should be your family name with estate, Doe Estate, John occupant of the Executor Office, Seattle, Washington, 99.9% pure silver, if it in fact is. You created it, why can you not put your seal on it? Now let us examine the other side of the coin. A Federal Reserve note is both a note and a dollar. It is a note in the sense that it represents a promise by the United States to pay the stated face amount of the instrument to the bearer on demand in lawful money. It is a dollar in the sense that the value of the note is stated in units of $1. The statutory authority for the creation and issuance of Federal Reserve notes is provided by 16 of the Federal Reserve Act, see 12 OSCS 411. That section provides that Federal Reserve notes, to be issued at the discretion of the Board of Governors of the Federal Reserve System, shall be obligations of the United States redeemable in lawful money on demand at the Treasury Department in Washington, D.C. or at any Federal Reserve Bank. In this connection, it should be noted that Federal Reserve notes are themselves lawful money. Although not defined by statute, the term lawful money is generally regarded as meaning any medium of exchange that freely circulates from hand to hand as money under sanction of law. The decisions of the courts indicate that lawful money includes the classes of money that are declared by the laws of the United States to be legal tender. Since Title 31 392 provides that all coins and currencies of the United States, including Federal Reserve notes, regardless of when coined or issued, are legal tender for all debts, a Federal Reserve note is legal tender. The gold ends here. 1933 March 9, a bank emergency bankruptcy was declared by President Roosevelt because of the insolvency of the United States. Executive Order 6073, 6102, 6111, 6260, Senate Report 93 to 549, PGS 187 and 594, 1973. 1933 March 9, the new money, paper promissory notes, is issued to the banks in return for government obligation debts, bills of exchange, drafts, notes, trade acceptances, and bankers' acceptances. The new money will be worth 100 cents on the dollar, because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. Senate Document Number 43, 73rd Congressional Record, First Session. Executive Order 6102, gold was transferred from U.S. citizens to the United States, 1933 May 1. Congressman Louis T. McFadden brought formal charges, Congressional Record May 23, 1933 page 4055 to 4058, against the Board of Governors of the Federal Reserve Bank System, the Controller of the Currency and the Secretary of United States Treasury for numerous criminal acts, including but not limited to, conspiracy, fraud, unlawful conversion and treason. The petition for articles of impeachment was thereafter referred to the Judiciary Committee and has yet to be acted on. 1933 June 5, to mitigate McFadden's charges, and prevent being hung for treason, Congress passed House Joint Resolution 192 to provide U.S. citizens the right to set off all government-obligated debts as the consideration, something bargained for, i.e., an exchange, for the transfer, theft, of all the gold and property. H.J.R. 192 Clause, June 5, 1933 73rd Cong, First Sess. Joint Resolution to assure uniform value to the coins and currencies of the United States. Whereas the holding of or dealing in gold affect the public interest, and therefore subject to proper regulation and restriction, and whereas the existing emergency has disclosed that provisions of obligations which purport to give the obligee a right to require payment in gold or a particular kind of coin or currency of the United States, or in an amount of money of the United States, measured thereby, obstruct the power of the Congress to regulate the value of money of the United States, and are inconsistent with the declared policy of the Congress to maintain at all times the equal power of every dollar, coined or issued by the United States, in the markets and in the payment of debts. Now, therefore, be it resolved by the Senate and House of Representatives of the United States of America in Congress assembled, that every provision contained in or made with respect to any obligation which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency, or in an amount in money of the United States measured thereby, is declared to be against public policy, and no such provision shall be contained in or made with respect to any obligation hereafter incurred. Every obligation, heretofore or hereafter incurred, whether or not any such provisions is contained therein or made with respect thereto, shall be discharged upon payment, dollar for dollar, in any such coin or currency which at the time of payment is legal tender for public and private debts. Any such provision contained in any law authorizing obligations to be issued by or under authority of the United States, is hereby repealed, but the repeal of any such provision shall not invalidate any other provision or authority contained in such law. As used in this resolution, the term obligation means an obligation, including every obligation of and to the United States, excepting currency, payable in money of the United States, and the term coin or currency means coin or currency of the United States, including Federal Reserve notes and circulating notes of Federal Reserve banks and national banking associations. SEC 2. The last sentence of paragraph 1 of subsection B of 43 of the Act entitled An Act to Relieve the
It should be going
Existing
to
national
Mexico.
economic emergency by increasing agricultural purchasing power to raise revenue for extraordinary expenses incurred by reason of
Like
such emergency,
scroll. I gotta
to
set it
provide
up like
emergency
right
relief with
now.
respect to
I'm doing
agricultural
better already because
indebtedness,
last time I had
to
all this in the window. So
provide
now
for
I
the
just got.
orderly liquidation
Well,
of
I could
joint
just
stock
focus on
land
that. They
banks,
can't see
and for
scrolling
other
over here. They
purposes,
can't see
approved
nothing.
May 12, 1933,
Too many
is amended
devices.
to read as follows: all coins and currencies of the United
This is good because
States,
I learned while I'm doing
including
it.
Federal Reserve notes and circulating notes of Federal Reserve banks and
Get more
national banking
understanding.
associations, heretofore or hereafter coined or issued, shall be legal tender for all debts, for public and private, public charges, taxes, duties, and dues, except that gold coins, when below the standard weight and limit of tolerance provided by law for the single piece, shall be legal tender only at valuation in proportion to their actual weight. Approved June 5, 1933, 4:30 p.m. Title 12.221 Definitions. The terms National Bank and National Banking
Move the computer
Association
around and go
shall
to the
be held to be
next one.
synonymous and interchangeable. Federal Reserve notes can only discharge, hand it off to another, a debt. A debt, to be extinguished, must be paid with value or substance, i.e. gold, silver, barter or a commodity. My actual labor is the equivalent of gold and silver. For this reason H.J.R. 192, 1933, which established the public policy of our current monetary system, repeatedly uses the technical term of discharge in conjunction with payment in laying out public policy for the new system. Now it is public policy, Public Law 73-10, that paying in gold or silver is no longer an option. If we are not using lawful money, gold or silver, then it has to be circulating notes in order to exchange them for FRNs. Circulating notes are the titles, birth certificates, death certificates, marriage license, social security cards, driver's license, voter's registration, and many other circulating papers issued by the government. This was done as an emergency act of Congress. This H.J.R. 192 is not an amendment, and neither resolutions, nor statutes can override the Constitution mandates. However, this would apply only to the Republican form of government, the United States of America, not the democracy, United States. Either way, Congress has their limitations. Cahavi United States, 152 U.S. 211, 215, 14 S.CT 513. The laws of Congress do not extend into the territorial limits of the states, but have force only in the District of Columbia, and other places that are within the exclusive jurisdiction of the national government. Thus, they had no authority, or did they? They created subdivisions of the U.S. corporation, called states, i.e. Oregon, Texas, Maine, Florida, and all the others. Zip codes indicate D.C., District of Columbia, subdivision, called states. By fraud, deception, and misdirection, they have deprived us of lawful money. However, that is not all they did. 1950 Congress declared bankruptcy and reorganization. Secretary of Treasury appointed receiver in the bankruptcy reorganization plan, number 26, 5 U.S.C.A. 903, Public Law 94-564, Legislative History, PG 5967. 1973. Since March 9, 1933, the United States has been in a state of declared national emergency, bankruptcy, Senate Resolution 9, 93D. Congress, First Session, Forward. 1977 October 28, the United States as a corporator and state declared insolvency. State banks and most other banks were put under control of the Governor, Secretary of the U.S. Treasury, of the Fund, IMF. 26 IRC 165, G. 1, UCC 1201. 23, CRS 39-22-103.5, Westfall vs. Braley, 10 Ohio 188, 75 AM December 509, Adams vs. Richardson, 337 SW2D. 911, Ward vs. Smith, 7 Wall 447. 1993 March 17, United States Congressional Record, Volume 33, page H1303. Speaker Rep. James Traficant, Jr., Ohio, addressing the House, Mr. Speaker, we are here now in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in world history, the U.S. government. It is an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt, being bankrupt and insolvent. HJR 192, 73rd Congress M. Session June 5, 1933 Joint Resolution to suspend the gold standard and abrogate the gold clause dissolved the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments, and is further evidence that the United States federal government exists today in name only. Government obligations discharged. Making way for discharge and recovery on U.S. corporate public debt due the principles and sureties of the United States, providing as public policy for the discharge of every obligation, including every obligation of and to the United States, dollar for dollar, allowing those backing the U.S. financial reorganization to recover on it by discharging an obligation they owe to the United States or its subcorporate entities, against that same amount of obligation of the United States owed to them, set off, thus providing the remedy for the discharge and orderly recovery of equity interest on U.S. corporate public debt due the sureties, principals, and holders of the United States, discharging that portion of the public debt without expansion of credit, debt, or obligation on the United States or these its prime creditors it was intended to satisfy equitable remedy to, but gaining for each bearer of such note, discharge of obligation equivalent in value dollar for dollar to any and all lawful money of the United States, credit. This is a few of the more important terms, there are many others within this section. 31 CFR 103.11 Meaning of terms. 9. Part 103, Financial Record Keeping and Reporting of Currency and Foreign Transactions. Subpart A, Definitions when used in this part and in forms prescribed under this part, where not otherwise distinctly expressed or manifestly incompatible with the intent thereof, terms shall have the meanings ascribed in this section. A. Except a receiving financial institution, other than the recipient's financial institution, accepts a transmittal order by executing the transmittal order. A recipient's financial institution accepts a transmittal order by paying the recipient, by notifying the recipient of the receipt of the order, or by otherwise becoming obligated to carry out the order. B. Bank. Each agent, agency, branch, or office within the United States of any person doing business in one or more of the capacities listed below. 1. A commercial bank or trust company organized under the laws of any state or of the United States. 2. A private bank. 3. A savings and loan association or a building and loan association organized under the laws of any state or of the United States. 4. An insured institution as defined in Section 401 of the National Housing Act. 5. A savings bank, industrial bank, or other thrift institution. 6. A credit union organized under the law of any state or of the United States. 7. Any other organization, except a money services business, chartered under the banking laws of any state and subject to the supervision of the bank supervisory authorities of a state. 8. A bank organized under foreign law. 9. Any national banking association or corporation acting under the provisions of Section 25A of the Act of December 23, 1913, as added by the Act of December 24, 1919, ch. 18, 41 Stat 378, as amended, 12 U.S.C. 611-32. D. Beneficiary. The person to be paid by the beneficiary's bank. H. Currency. The coin and paper money of the United States or of any other country that is designated as legal tender and that circulates and is customarily used and accepted as a medium of exchange in the country of issuance. Currency includes U.S. silver certificates, U.S. notes, and Federal Reserve notes. Currency also includes official foreign bank notes that are customarily used and accepted as a medium of exchange in a foreign country. K. Domestic. When used herein, refers to the doing of business within the United States, and limits the applicability of the provision where it appears to the performance by such institutions or agencies of functions within the United States. N. Financial institution. Each agent, agency, branch, or office within the United States of any person doing business, whether or not on a regular basis or as an organized business concern, in one or more of the capacities listed below. 1. A bank, except bank credit card systems. 7. A person subject to supervision by any state or federal bank supervisory authority. U. Monetary instruments. 1. Monetary instruments include I. Currency. 2. Traveler's checks in any form. 3. All negotiable instruments, including personal checks, business checks, official bank checks, cashier's checks, third-party checks, promissory notes, as that term is defined in the Uniform Commercial Code, and money orders, that are either in bearer form, endorsed without restriction, made out to a fictitious payee, for the purposes of 103.23, or otherwise in such form that title thereto passes upon delivery. 4. Incomplete instruments, including personal checks, business checks, official bank checks, cashier's checks, third-party checks, promissory notes, as that term is defined in the Uniform Commercial Code, and money orders, signed but with the payee's name omitted, and v. securities or stock in bearer form or otherwise in such form that title thereto passes upon delivery. 2. Monetary instruments do not include warehouse receipts or bills of lading. E. Payment order. An instruction of a sender to a receiving bank, transmitted orally, electronically, or in writing, to pay, or to cause another bank or foreign bank to pay, a fixed or determinable amount of money to a beneficiary if, 1. The instruction does not state a condition to payment to the beneficiary other than time of payment, 2. The receiving bank is to be reimbursed by debiting an account of, or otherwise receiving payment from, the sender, and 3. The instruction is transmitted by the sender directly to the receiving bank or to an agent, funds transfer system. 14th Amendment. Look at the Constitution of the United States, 14th Amendment 4, the validity of the public debt of the United States, authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred. 10. In aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. You cannot argue the validity of public debt. Neither the U.S. nor the states are responsible for the repayment of the debts. Who is left? People. Incurred in aid of insurrection, that is what the federal government did. They attacked the Constitution by this very amendment. Both the 13th and 14th Amendments are an act of rebellion against the Republic. How can I say such a thing? Did they in any way, shape, or form, abrogate the requirement for payments to be in gold or silver coins? If they did not abrogate, the requirement is still valid. Abrogate, verb with object repeal or do away with, a law, right, or formal agreement, within the Constitution itself, then all debts must be paid in silver or gold. How is this not a violation of their oath of office? If this does violate their oath of office, then it is an act of treason. They have a right to abolish any government they create when in the course of human events it becomes necessary to preserve life, liberty, and the pursuit of happiness. However, they did not do so. They allowed democracy to take over and put the guaranteed republican form of government to sleep. Why asleep? It is guaranteed, we have access to it at any time. The very people that swore an oath to protect and defend the Constitution, are now rebellious, an act of sedition, or insurrection, a coup d'état, and all good people, acting as they have in the past, flip to being rebellious because rebellion is the norm and the norm is now rebellious. How did they do this? By turning the world upside down. Section 3. No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath, as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. The Civil War itself was an act of insurrection. We have freedom in this country, if the people cannot leave to whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it is an act of slavery itself. Nowhere does it state that the federal government can force any state to remain if they choose to leave. Southern states walked out of Congress, the United States of America ceased to exist. War began, illegally, as it takes an act of Congress to declare war and Congress was no more. Democracy was born by an act of rebellion. All who partook in the act could no longer be a part of the government, republican form of government, nor the democracy. For the lack of confusion they added the sentence after, but Congress may by a vote of 2/3 of each house, remove such disability. What house? It was disbanded. So if all we excommunicated out of the republican form of government, who can remove such disability? The people who they declared cannot hold an office? If you cannot hold an office, you cannot have 2/3 vote on anything. Funny thing is you cannot even pass this amendment as they had no authority to do so by this very act. Therefore, who removes the disability? I believe insurrectionist, aka Congress. To further add insult to injury, Section 2. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and citizens of the United States, or in any way abridged, except for participation in rebellion, or other crime, the basis of representation therein shall be reduced, in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. This, basically, states the right to vote for an elected official in any one of the three branches of government is denied, except for in an act of rebellion. Who now can create all the public debt they want? All the voters who support insurrectionists are not rebellious by doing what they have always done, and all the debt is held to be illegal and void. Why is there is in Section 1, concerning due process of law when that was established in the Fifth Amendment. The Fifth Amendment is for Americans in the republican form of government. Due process in the 14th Amendment is for the democracy. Thus, democracy is born, corporation rules, and the people died, at least on paper. We no longer are electors, we are voters, we no longer have statesmen, we have candidates. There is a reason for the change in language, it is a different spell. When were birth certificates created, in the republic or the democracy? How did God feel about census, counting his people? You can count your people, you cannot count his people. So congratulations, if you support the democracy, you reject God, you are rebellious, a debtor, and if you support the republican form of government, and this was guaranteed in Article 4.4, you are an enemy to the democracy. Gold and silver must be used to pay debts in the republican form of government, however, no so in the democracy. Have you ever complained that the national debt is too big? Stop your whining. The debt shall not be questioned. If you cannot see Congress balancing the budget, read it. They do not have to. They are not responsible for repayment of the debts. These same debts are held illegal and void. People are responsible for the repayment of the debts and, without gold or silver. Here is the tricky part: how can a public servant demand masters be responsible of the debts the public servants create? Answer: they cannot. They just say, neither Mr. Doe or I are responsible, neither the United States nor any state shall assume or pay any debt or obligation, and to appease the we, the people, all such debts, obligations, and claims shall be held illegal and void. How are we, the people, to repay the debt or obligations of the United States? What are obligations? They are held to be illegal and void, until we accept them for value. 11. In God, government obligated discharge, we trust. Does the government use acronyms? Put things in all capital letters? The answer to both is absolutely. Is the government obligated to settle debts? First, let us look at obligations of the United States. Title 18(8). Obligation or other security of the United States defined. The term obligation or other security of the United States includes all bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve Bank notes, coupons, United States notes, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposit, bills, checks, or drafts for money, drawn by or upon authorized officers of the United States, stamps and other representatives of value, of whatever denomination, issued under any act of Congress, and canceled United States stamps. FRNs are obligations of United States, HJR 192. The term obligation means Federal Reserve notes and circulating notes of Federal Reserve banks and national banking associations. How odd that my birth certificate is printed by the America Bank Note Company, or some other institution. This is circulating paper. Remember, debts, obligations and claims, shall be held illegal and void. Democracy is not all bad. It is a fact. Title 31 3123 makes a statutory pledge of the United States government to payment of obligations and interest on the public debt. Title 31 3123. Payment of obligations and interest on the public debt. A. The faith of the United States government is pledged to pay, in legal tender, principal and interest on the obligations of the government issued under this chapter. C. 3. The Secretary may designate depositaries in foreign countries in which any part of the proceeds of bonds, notes, or certificates of indebtedness payable in the foreign currency may be deposited. Therefore, the government pledges to pay government obligations of which our FRNs are and pay them with FRNs, which is legal tender. If we give them $1, they give us $1. Lawyers are not stupid, they cast a mean spell but not stupid. Taxes and all bills associated with corporations are all government obligations in which they must pay when we accept them for value and return them to the government that has an obligation to settle the debt, dollar for dollar. It is a fact. Title 31 3130 further delineates in its definitions a portion of the total public debt, which is held by the public as the net public debt. 3130. Annual Public Debt Report. A. General Rule. On or before June 1 of each calendar year after 1993, the Secretary of the Treasury shall submit a report to the Committee on Ways and Means of the House of Representatives and the Committee on Finance of the Senate on 1. The Treasury's public debt activities, and 2. The operations of the Federal Financing Bank. For whatever reason we can associate with their actions and reasons, they did so we may benefit. We are beneficiaries, they, the government are trustees, trustees pay debts, beneficiaries do not. Thus, government obligations, which are illegal and void, are not taxable. Just try and not pay then the extortion they want. Nevertheless, we must settle with our advisory quickly. These obligations of United States are not taxable, Title 31 3124. Exemption from taxation. A. Stocks and obligations of the United States government are exempt from taxation by a state or political subdivision of a state. The exemption applies to each form of taxation that would require the obligation, the interest on the obligation, or both, to be considered in computing a tax, except 1. A non-discriminatory franchise tax or another non-property tax instead of a franchise tax, imposed on a corporation, and 2. An estate or inheritance tax. B. The tax status of interest on obligations and dividends, earnings, or other income from evidences of ownership issued by the government or an agency and the tax treatment of gain and loss from the disposition of those obligations and evidences of ownership is decided under the Internal Revenue Code of 1986, 26 U.S.C. 1 ETSEQ. An obligation that the Federal Housing Administration had agreed, under a contract made before March 1, 1941, to issue at a future date, has the tax exemption privileges provided by the authorizing law at the time of the contract. This subsection does not apply to obligations and evidences of ownership issued by the District of Columbia, a territory or possession of the United States, or a department, agency, instrumentality, or political subdivision of the district, territory, or possession. Keep in mind also the Constitution does not give, we, the people rights. It forbids the government to ignore the God-given rights of the people, as seen in the Ninth Amendment. The enumeration in the Constitution, of certain rights, shall not be construed to deny or disparage others retained by the people. In addition, the 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Is there anything to discourage the people from creating credit instruments? In fact, by the 14th Amendment, we need to. We 12. Must accept for value, the debt instruments of the U.S. democracy. As long as the debt exists, the democracy exists. The Republican form of government, the United States of America, can only come back when the debt is gone. How will you pay for it, to make the national debt go away? If you gave all the FRNs back, the interest alone would be so huge it would be impossible to pay back. Even more so, when you realize, giving all the FRNs back cannot pay for anything. Using FRNs to pay debts only increases the government obligations on debt. Let the trustee settle the claims, but you need to give them permission of let them know of the debt. Trust. When we gather of two or more, we invoke a higher power, Matthew 18:20. We can also create fictions. Corporations require at least 3 positions. Trusts require at least 3 positions. Christianity has 3 positions, all one God, but each has a distinct purpose. When the laying of hands on a goat, or in some societies, a virgin, to be sacrificed for sins, to be forgiven, it required 3, you trust that your sins are forever gone. In our society, it is all by trusts, and we are not taught what or how trusts operate, or at least I was not. What is the law definition of a trust? Trust, if often thought of as being reliable, something or someone you believe. However, this is between people. When we deal with the fictional, man-made creations, we need to look at the legal. Find me in their codes, statutes, rules, regulations, laws, bills that provide even one word in which it means something other than a legal trust. Trust, law, confidence placed in a person by making that person the nominal owner of property to be held or used for the benefit of one or more others, an arrangement whereby property is held in such a way. A body of trustees, an organization or company managed by trustees, dated a large company that has or attempts to gain monopolistic control of a market, trusts someone/something to commit someone or something to the safekeeping of. 63 Cam Jur. 2d. Public officers and employees. 247. As expressed otherwise, the powers delegated to a public officer are held in trust for the people and are to be exercised in behalf of the government or of all citizens who may need the intervention of the officer. 1. Furthermore, the view has been expressed that all public officers, within whatever branch and whatever level of government, and whatever be their private vocations, are trustees of the people, and accordingly labor under every disability and prohibition imposed by law upon trustees relative to the making of personal financial gain from a discharge of their trusts. 2. That is, a public officer occupies a fiduciary relationship to the political entity on whose behalf he or she serves. 3. In addition, owes a fiduciary duty to the public. 4. It has been said that the fiduciary responsibilities of a public officer cannot be less than those of a private individual. 5. Furthermore, it has been stated that any enterprise undertaken by the public official, which tends to weaken public confidence and undermine the sense of security for individual rights, is against public policy. Will you honor the laws, rules, regulations, and operational requirements etc. of this government? Above are not my words, they are words of the government. It comes from their judicial Bible. Also, know the slaves cannot pay for anything, as all they have belongs to their master. Beneficiaries cannot pay for anything, as that is the duty of the trustee, who has a fiduciary duty to discharge the requirements of the trust. When do we pay for something? When we are dealing with people, not artificial entities, or public servants. The government has no business in interfering in the private affairs of the people. The government is doing its best to destroy any private affairs we might have. Executive Orders. 6073 Reopening of banks. Embargo on gold payments and exports, and limitations on foreign exchange transactions. March 10, 1933. 6111 Transactions in foreign exchange are permitted under governmental supervision. April 20, 1933. 6102. Forbidding the hoarding of gold coin, gold bullion, and gold certificates. April 5, 1933. Debts are payable only by gold or silver. This is U.S. currency, we do not have it, and now forbidden to use it, and the debt falls on the people and debts are held illegal and void. Congress created an impossibility, confusion, on the one hand, and insanity and fraud on the other hand, and then place it on the people outside their jurisdiction, while making all public servants trustee to the debts. It is now constitutional to create illegal and void debts for the people to repay that which is illegal and void. It is a joke. Ask the people in prison if it is a joke. Someone has to be surety, Proverbs 6:1. Matthew 17:24-27. And when they had come to Capernaum, those who took the temple tax came to Peter and said, "Does not your master make payment of the temple tax?" He says, "Yes." And when he came into the house, Jesus said to him, "What is your opinion, Simon? From whom do the kings of the earth get payment or tax? From their sons or from other people?" And when he said, "From other people," Jesus said to him, "Then are the sons free. But, so that we may not be a cause of trouble to them, go to the sea, and let down a hook, and take the first fish which comes up, and in his mouth you will see a bit of money, take that, and give it to them for me and you." What happened? People who are not responsible for the debt have to pay. What can they do? They accept for value the tax, regardless of who was responsible. For foreigners are responsible for the tax. Federal Reserve is not a government entity, it is 13. A foreign entity. If the obligation is illegal and void, accepting it for value is a valid method to resolve the illegal and void claim of debt that we cannot challenge. Congress in the creation of the democracy, had to set it apart from the republic, and they did this by creating a corporation. This corporate government needed citizens, and they created citizens via the birth certificate. They made them unique by making it all uppercase name, capitalization, money. We are also described as being a vessel in the Holy Bible. A vessel, you find that in the United States Government Printing Office Style Manual 11.7, names of vessels are quoted in matters printed in other than lowercase Roman. It is a way to say uppercase Roman or capitalization under Roman laws without saying it. Perhaps Roman is the typeface, perhaps it the form of law. A vessel is defined in Title 18:9. The term vessel of the United States as used in this title means a vessel belonging in whole or in part to the United States or any citizen thereof or any corporation created by or under the laws of the United States or any state or territory or district or possession. These all uppercase names, created by a birth certificate, are now U.S. citizens, and what allows the democracy to borrow foreign money. Birth certificates are circulating notes. If you look close, you will see that these birth certificates are printed on bond paper, and it usually has some banknote company Y. It is now a security, in order for the democracy to create funds for the citizens to use. All of these security instruments, circulating paper, belongs to the government. All the debts, accounts, credits, funds, and numbers belong to the government. It is their debt. Nevertheless, we, the people, have to settle the debt. Thus, we, Americans, are the creditors. The all money name, uppercase, capital/capital, are the debtors, U.S. citizens. Americans are only the authorized representatives of all the numbered circulating instruments. Look at the signature line on your check, use a magnifier, to read the fine print, not only on checks, but nearly every kind of monetary instrument, checks, money orders, and the backs of cards, usually say authorized representative, signature, agent, or they claim it as their property, including your signature, which makes you authorized for these accounts, and we, the people, are the surety of the money, all capital, name. Why would I need to be / have an authorized signature / agent for myself? I would understand it if I authorized you to act in my name, so whose name am I acting in, if not my own? Who has the authority? Authorized adjective. One given or endowed with authority, an authorized agent. 2 duly sanctioned. Verb, used with object, ised, ising. 1 to give authority or official power to, empower, to authorize an employee to sign purchase orders. 2 to give authority for, formally sanction, an act or proceeding Congress authorized the new tax on tobacco. 3 to establish by authority or usage, an arrangement long authorized by etiquette books. 4 to afford a ground for, warrant, justify. Are we given authority by a soulless creation of man, or endowed with authority? Genesis 1:28 And God blessed them, and God said unto them, Be fruitful, and multiply, and replenish the earth, and subdue it, and have dominion over the fish of the sea, and over the fowl of the air, and over every living thing that moveth upon the earth. Who created the government? So, we ask, what is the definition of authority? Authority, n. The power or right to control, judge, or prohibit the actions of others. 2. Often plural, a person or group of people having this power, such as a government, police force, etc. 3. A position that commands such a power or right, often in the phrase in authority. 4. Such a power or right delegated, especially from one person to another, authorization, she has his authority. 5. The ability to influence or control others, a man of authority. 6. An expert or an authoritative written work in a particular field, he is an authority on Ming China. 7. Evidence or testimony, we have it on his authority that she is dead. 8. Confidence resulting from great expertise, the violinist lacked authority in his cadenza. 9. Government, politics and diplomacy, capital when part of a name, a public board or corporation exercising governmental authority in administering some enterprise, independent broadcasting authority. 10. Law. Law. A judicial decision, statute, or rule of law that establishes a principle, precedent. B. Legal permission granted to a person to perform a specified act, from French auto right, from Latin auctoritas, from auctor author. Settler. Since the government or corporations created by the government has made up all these numbers as U.S. citizens, and for U.S. citizen, these are all debtors, debtors cannot create anything but debt instruments. American people, or any freeman worldwide, are needed for settling the debts. Therefore, the people, non-citizens of the U.S., are creditors or grantors. In addition, realize that the government gets its authority from the people. The government cannot have authority that people do not have. The created cannot have more authority than the Creator. Ask your God, do you have more authority than your God? The created is subservient to the Creator. Remember the words of the Declaration of Independence: we, the people, do ordain and 14. Establish. Who? The people, not corporations or government authorities. The people claim to have the authority, the government is the creation of the people, and it is not our master, at least it is not my God. Exodus 20:5 Thou shalt not bow down thyself to them, nor serve them, for I the Lord thy God am a jealous God, visiting the iniquity of the fathers upon the children unto the third and fourth generation of them that hate me. Matthew 4:8-10 Again, the devil taketh him up into an exceeding high mountain, and sheweth him all the kingdoms of the world, and the glory of them, and saith unto him, All these things will I give thee, if thou wilt fall down and worship me. Then saith Jesus unto him, Get thee hence, Satan, for it is written, Thou shalt worship the Lord thy God, and him only shalt thou serve. How can one give, or promise to give, what is not theirs? Governments, money-based creations, are not of God. Luke 16:13 No man may be a servant to two masters, for he will have hate for the one and love for the other, or he will keep to the one and have no respect for the other. You may not be servants of God and of wealth. Government is an illusion. 1 Samuel 8:7 The creating a government like all other nations is a rejection of God. The elders demanded a king due to the corruption of judges, and by rejecting God as their king. We start at 8:4 Then all the elders of Israel gathered themselves together, and came to Samuel unto Ramah. 5 And they said unto him, Behold, thou art old, and thy sons walk not in thy ways, now make us a king to judge us like all the nations. 6 But the thing displeased Samuel, when they said, Give us a king to judge us. And Samuel prayed unto Jehovah. 7 And Jehovah said unto Samuel, Hearken unto the voice of the people in all that they say unto thee, for they have not rejected thee, but they have rejected me, that I should not be king over them. 8 According to all the works which they have done since the day that I brought them up out of Egypt even unto this day, in that they have forsaken me, and served other gods, so do they also unto thee. Wealth is an illusion, it is actually a method to kill others by doing nothing, for it appears that money buys health, doctors, hospitals, when actually, money prevents you to get what you need. Look at the medicine companies, their goal is to make a profit, not to heal. They supply potions, spells in demonic forms, pills, not God-created healing herbs. Wealth rules. What happened to God? God is lost in health, politics, courts, and churches. Who needs the four horsemen of the Revelation apocalypse, when we have wealth, mammon? We are ignorant. Is there any hope for us? We try to exit out of and exist without government, and settle the alleged debts. One of the ways is to accept for value. Do you prefer to argue? Dishonor what the government itself says? Agree, accept, settle the claim. Let me make this clear as well. Money is not evil, it has no thought, no desire, no existence. God does have love, forgiveness, and more. The Antichrist, the beast, may have created this monetary system, but it does not control us. Money is only a magnifying glass, only allow you to see more of what you are. If you are greedy, you become more so. If you are generous, you become more so. Money is a reflection of your talent and ability to help others. Money gives you freedom, even more now than ever before. Money is not the result, it is a medium to gather people together, to create, to enjoy, to explore, to assist, and more. Federal Reserve notes are an illusion, but do not let that interfere from helping you being entertained and helping others. Most people have good hearts, they get desperate when faced with starvation or extinction. Most people want to help others. Money can be a tool to do the greatest good or the most damning harm. Let me make this clear as well. Money is not evil, it has no thought, no desire, no existence. God does have love, forgiveness, and more. The Antichrist, the beast, may have created this monetary system, but it does not control us. Money is only a magnifying glass, only allow you to see more of what you are. If you are greedy, you become more so. If you are generous, you become more so. Money is a reflection of your talent and ability to help others. Money gives you freedom, even more now than ever before. Money is not the result, it is a medium to gather people together, to create, to enjoy, to explore, to assist, and more. Federal Reserve notes are an illusion, but do not let that interfere from helping you being entertained and helping others. Most people have good hearts, they get desperate when faced with starvation or extinction. Most people want to help others. Money can be a tool to do the greatest good or the most damning harm. It is up to the one holding the paper. Money harms nothing, it is the man holding money that decide, heaven or hell, God or wealth, living or dead. Are we supposed to hide our talents under a bush? Money allows one to influence others, prevent others from making demands on your ability, allow people to be injured by doing nothing, gathering people of like abilities to create. Money can be used as a tool for making your dreams or nightmares come true. We are to take what we have and make our talents grow. Earn much, give generously, teach many, enjoy living to the fullest. When asked to pay taxes, accept it for value without question. Authorized liability. According to the UCC, Uniform Commercial Code, the authorized representative is not held liable. Remember, you are an authorized person for the government-created accounts. Again, look at the signature lines on the things you pay for. Who is liable for the illegal and void debts? The government, which is to say, U.S. citizens, as they are the debtors, created by a corporate beast. Governments, corporations, and wealth have one thing in common: feet of clay, Daniel 2:42. The AFV needs the words authorized representative with your name. In addition, the verbiage on the AFV may also have without recourse. What does without recourse and representative mean? UCC 3-415, b. If an endorsement states that it is made without recourse or otherwise disclaims liability of the endorser, the endorser is not liable under subsection A, to pay the instrument. UCC 3-402. A. If a person acting, or purporting to act, as a representative signs an instrument by signing either the name of the represented person or the name of the signer, the represented person is bound by the signature to the same extent the represented person would be bound if the signature were on a simple contract. If the represented person is bound, the signature of the representative is the authorized signature of the represented person, and the represented person is liable on the instrument, whether or not identified in the instrument. B. If a representative signs the name of the representative to an instrument and the signature is an authorized signature of the represented person, the following rules apply. 15. 1. If the form of the signature shows unambiguously that the signature is made on behalf of the represented person who is identified in the instrument, the representative is not liable on the instrument. 2. Subject to subsection C. If I. The form of the signature does not show unambiguously that the signature is made in a representative capacity, or 2. the represented person is not identified in the instrument, the representative is liable on the instrument to a holder in due course that took the instrument without notice that the representative was not intended to be liable on the instrument. With respect to any other person, the representative is liable on the instrument unless the representative proves that the original parties did not intend the representative to be liable on the instrument. C. If a representative signs the name of the representative as drawer of a check without indication of the representative status and the check is payable from an account of the represented person who is identified on the check, the signer is not liable on the check if the signature is an authorized signature of the represented person. Forbidden gold. Is there a code that claims all this craziness concerning gold? Does it matter? Yes, it matters, as you are a U.S. citizen by the all money name, uppercase, capitalization, a vessel. If you cannot use gold to pay debts and now cannot use gold to pay debt obligations, then how does one pay debts? It is written, so shall it be, therefore. USC, U.S. Code or Title, 31, 5118. Gold clauses and consent to sue. A. In this section. 1. Gold clause means a provision in or related to an obligation alleging to give the obligee a right to require payment in a. Gold. B. A particular United States coin or currency, or c. United States money measured in gold or a particular United States coin or currency. 2. Public debt obligation means a domestic obligation issued or guaranteed by the United States government to repay money or interest. B. The United States government may not pay out any gold coin. A person lawfully holding United States coins and currency may present the coins and currency to the Secretary of the Treasury for exchange, dollar for dollar, for other United States coins and currency, other than gold and silver coins, that may be lawfully held. The Secretary shall make the exchange under regulations prescribed by the Secretary. C. 1. The government withdraws its consent given to anyone to assert against the government, its agencies, or its officers, employees, or agents, a claim. A. On a gold clause public debt obligation or interest on the obligation. B. For United States coins or currency, or c. Arising out of the surrender, requisition, seizure, or acquisition of United States coins or currency, gold, or silver involving the effect or validity of a change in the metallic content of the dollar or in a regulation about the value of money. 2. Paragraph 1 of this subsection does not apply to a proceeding in which no claim is made for payment or credit in an amount greater than the face or nominal value in dollars of public debt obligations or United States coins or currency involved in the proceeding. 3. Except when consent is not withdrawn under this subsection, an amount appropriated for payment on public debt obligations and for United States coins and currency may be expended only dollar for dollar. D. 1. In this subsection, obligation means any obligation, except United States currency, payable in United States money. 2. An obligation issued containing a gold clause or governed by a gold clause is discharged on payment, dollar for dollar, in United States coin or currency that is legal tender at the time of payment. This paragraph does not apply to an obligation issued after October 27, 1977. So this all means in Title 31 5118, you have gold coins that you can replace them with FRNs dollar for dollar. B. What a rip-off. The government withdraws its consent to assert a claim against the government, c. 1. Yet they will settle dollar for dollar, c. 3, when consent is not withdrawn, payment on a public debt. It can be discharged dollar for dollar, d. 2. It is their law and affects the all money name. So, there has to be a remedy, or this would be a huge conflict. What does this say? You can use the government to settle your illegal and void debts dollar for dollar. Americans are foreign to the democracy. What we do is always foreign on behalf of the U.S. citizen, as a representative of the public debt, all money name, which Americans have to settle. Foreigners have to settle the debts of the United States, as all things created in the democracy are debtors, and debtors cannot create credit. Can FRNs be used to pay debts? No. In Chart v. Commissioners C.C. 42 FD2D 158, giving note, Federal Reserve, does not constitute payment and legal tender. Federal Reserve, notes are not good and lawful money of the United States. See Raines v. State, 226 SW 189. What have you actually paid for? Nothing. Who owes it? The democracy, as all property. 16. Is abandoned. We have made no valid claims. These are just a form of a promise to pay. The use of a Federal Reserve note is only a promise to pay. See Fidelity Savings v. Grimes, 131 P2D 894. Just try to redeem FRNs at a bank, even if it says you can. Section 16 of the current Federal Reserve Act, which is codified at Title 12 411, Issuance to Reserve Banks, Nature of Obligation, Redemption. Federal Reserve Notes, to be issued at the discretion of the Board of Governors of the Federal Reserve System for making advances to Federal Reserve Banks through the Federal Reserve agents as hereinafter set forth and for no other purpose, are authorized. The said notes shall be obligations of the United States and shall be receivable by all national and member banks and Federal Reserve banks and for all taxes, customs, and other public dues. They shall be redeemed in lawful money on demand at the Treasury Department of the United States, in the City of Washington District of Columbia, or at any Federal Reserve Bank. Payback. Even though in the case, Guarantee Trust of New York v. Henwood, 1977, makes reference to Title 31 5118, legal tender for the discharge of debt is no longer required. Legal tender are Federal Reserve notes. The Federal Reserve Bank of Chicago in its booklet, Modern Money Mechanics, page 2, states, in the United States neither paper currency example Federal Reserve notes nor deposits have value as commodities. Intrinsically, a dollar bill is just a piece of paper, deposits merely book entries. The acceptance of said currency is merely a confidence game predicated upon the people's faith or confidence that these currencies/instruments can be exchanged/accepted for goods and services. Does this go against the law? Absolutely. It is treason. From the document there is no legal tender. It concluded with in Section 1 of HJR 192 there is a single very important sentence, which states, any such provision contained in any law authorizing obligations to be issued by or under the authority of the United States, is hereby repealed. This is hugely important because under 16 of the Federal Reserve Act, above, at Part 1, the Federal Reserve notes issued under that section were expressly said to be obligations of the United States. Then, in June of 1933 the authority to issue those 16 Federal Reserve notes was repealed. Result: all Federal Reserve or Reserve notes are without authority of law. If there is a method to get the government to settle the claims of the public debt, what is it? After all, this is the only way we can actually claim our property, toys, our lives, and get rid of the national debt. The United States Supreme Court said, in United States v. Russell 13 Wall, 623, 627 private property, the Constitution provides, shall not be taken for public use without just compensation. The national debt is defined as mortgages on the wealth and income of the people of a country. Encyclopedia Britannica, 1959. The United States cannot pledge or risk the property and wealth of its private citizens, for any government purpose without legally providing them remedy to recover what is due them on their risk. Black's Law Dictionary, 5th edition, defines surety, one who undertakes to pay or to do any other act in event that his principal fails therein. Everyone who incurs a liability in person or estate for the benefit of another, without sharing in the consideration, stands in the position of a surety. The rights of a surety to recovery on his risk or loss when standing for the debts of another was reaffirmed again as late as 1962 in Perlman v. Reliance Insco, 371 U.S. 132. When the court said, sureties compelled to pay debts for their principal have been deemed entitled to reimbursement, even without a contractual promise. Value. What can we do? Accepted for value or accept for value. When you accept the illegal, void, non-gold, or non-silver related debt, then you, the creator of governments, give it value. Are you not the sons and daughters of God? Ambassadors. Representation of God, to do all acts in his name. John 14:13, John 14:14, John 16:23, John 16:26. Sovereigns can create money or value. What of the law of nations? I have never signed up or agreed to the law, therefore, value is whatever I claim it to be and you accept. However, no country or other sovereign has to accept it. There lies the problem, my creation may not be recognized by anyone. But wait. UCC 1-204, except as otherwise provided in Articles 3, 4, and 5, and 6, a person gives value for rights if the person acquires them. 1. In return for a binding commitment to extend credit or for the extension of immediately available credit, whether or not drawn upon and whether or not a chargeback is provided for in the event of difficulties in collection. 2. As security for, or in total or partial satisfaction of, a pre-existing claim. 3. By accepting delivery under a pre-existing contract for purchase, or 4. In return for any consideration sufficient to support a simple contract. 17. UCC 3-419. A. If an instrument is issued for value given for the benefit of a party to the instrument, accommodated party, and another party to the instrument, accommodation party, signs the instrument for the purpose of incurring liability on the instrument without being a direct beneficiary of the value given for the instrument is signed by the accommodation party for accommodation. B. An accommodation party may sign the instrument as maker, drawer, acceptor, or indexer and, subject to subsection D, is obliged to pay the instrument in the capacity in which the accommodation party signs. The obligation of an accommodation party may be enforced notwithstanding any statute of frauds and whether or not the accommodation party receives consideration for the accommodation. C. A person signing an instrument is presumed to be an accommodation party and there is notice that the instrument is signed for accommodation if the signature is an anomalous endorsement or is accompanied by words indicating that the signer is acting as surety or guarantor with respect to the obligation of another party to the instrument. Except as provided in Section 3-605, the obligation of an accommodation party to pay the instrument is not affected by the fact that the person enforcing the obligation had notice when the instrument was taken by that person that the accommodation party signed the instrument for accommodation. D. If the signature of a party to an instrument is accompanied by words indicating unambiguously that the party is guaranteeing collection rather than payment of the obligation of another party to the instrument, the signer is obliged to pay the amount due on the instrument to a person entitled to enforce the instrument only if I. Execution of judgment against the other party has been returned unsatisfied. 2. The other party is insolvent or in an insolvency proceeding. 3. The other party cannot be served with process, or 4. It is otherwise apparent that payment cannot be obtained from the other party. E. If the signature of a party to an instrument is accompanied by words indicating that the party guarantees payment or the signer signs the instrument as an accommodation party in some other manner that does not unambiguously indicate an intention to guarantee collection rather than payment, the signer is obliged to pay the amount due on the instrument to a person entitled to enforce the instrument in the same circumstances as the accommodated party would be obliged, without prior resort to the accommodated party by the person entitled to enforce the instrument. F. An accommodation party who pays the instrument is entitled to reimbursement from the accommodated party and is entitled to enforce the instrument against the accommodated party. In proper circumstances, an accommodation party may obtain relief that requires the accommodated party to perform its obligations on the instrument. An accommodated party that pays the instrument has no right of recourse against, and is not entitled to contribution from, an accommodation party. UCC 3-103, A. 1. Acceptor means a drawee who has accepted a draft. 4. Drawee means a person ordered in a draft to make payment. 7. Maker means a person who signs or is identified in a note as a person undertaking to pay. Bank. The legal, statutory and professional definitions of bank, banking, and banker used in the United States Code and Code of Federal Regulations are not those commonly understood for these terms and have made the statutory definition of bank accordingly. AUCC 4-105 Part 1 Bank means a person engaged in the business of banking. B12 CFR Sector 229.2 Definitions. E. Bank means the term bank also includes any person engaged in the business of banking. C12 CFR Sector 210.2 Definitions. D. Bank means any person engaged in the business of banking. D. The term person means a legal fiction, corporation or trust, construct such as Patricia A. Morris Transmitting Utility. E. Title 12 Sector 1813. Definitions of bank and related terms. 1. Bank. The term bank, A, means any national bank, state bank, and district bank, and any federal branch and insured branch. F. Black's Law Dictionary, 5th edition, page 133, defines a banker as, in general sense, person that engages in business of banking. In narrower meaning, a private person, who is engaged in the business of banking without being incorporated. Under some statutes, an individual banker, as distinguished from a private banker, is a person who, having complied with the statutory requirements, has received authority from the state to engage in the business of banking, while a private banker is a person engaged in banking without having any special privileges or authority from the state. G. Banking is partly and optionally defined as the business of issuing notes for circulation, negotiating bills. H. Black's Law Dictionary, 5th edition, page 133, defines banking. The business of banking, as defined by law and custom, consists in the issue of notes intended to circulate as money. 18. IN defines a banker's note as a commercial instrument resembling a banknote in every particular except that it is given by a private banker or unincorporated banking institution. J. In the absence of a statutory definition, courts give terms their ordinary meaning. Base, Terry L. V. Stolper. Koritsinski, 111 F.3d 1325, 7 THCIR. Apps. 1996. K. As the U.S. Supreme Court noted, we have stated time and again that courts must presume that a legislature says in a statute what it means and means in a statute what it says there. See, example United States v. Ron Peer Enterprises Incorporated, 489 U.S. 235, 241 to 242, 1989, United States v. Goldenberg, 168 U.S. 95, 102-103, 1897. We, the people, are banks. So, to whom do we make these except for values out to? The way I see it, these codes said Treasury Department is to settle the debts. However, the IRS is the accounting and collection department of the Treasury Department. Let us see what the IRS has to say. Internal Revenue. IRM 3.8.44.4.2, if remittance is not made payable to the United States Treasury or one of the acceptable payees listed below, pull the remittance and source document en route to the Payment Perfection Unit. Payee. Internal Revenue Service, United States Treasury. U.S. Treasury/U.S. Treasury Department of the Treasury/Department of Treasury IRS Director, or Commissioner, of Internal Revenue Estimated Tax. Federal Tax Deposit, FTD. Social Security Administration, or SSA. FICA Other U.S. Government Agency. Taxpayer, Personal Check or Money Order. Third party. Variations of any agency or department of the United States government should be construed to be a payment to the United States government. State agency or franchise tax board. Accept/reject. Accept, accept. 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 Accept, accept if clearly intended as FDD payment. Accept if received with SSA Form 4511. Accept, 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 accept if taxpayer has endorsed. Reject if taxpayer has not endorsed. Reject unless third party has endorsed. If third party has endorsed the check over to the taxpayer must also have endorsed. Accept. Accept if money amount matches the federal document. Overstamp/endorse. No, no. 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 Overstamp. 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 Endorse for deposit only. United States Treasury below last endorsement. Endorse for deposit only. United States Treasury below last endorsement. Overstamp. Overstamp. Even the Internal Revenue Service, according to the IRM at 3.8.45.4.9, cannot accept gold or silver in payment of taxes, which taxes are a debt. This then appears to follow the United States titles. So, why have it here as well? Unless, the IRS is not a department of the U.S. Treasury as we understand it, or subject to the codes of the U.S. 19. If you will notice that if this is not done correctly, that is, made payable to the United States Treasury, it is to be sent to the Perfection Department, that is where they change who make it payable to. In other words, if you accidentally send in your heating bill payment to the IRS, they correct it to make it payable to the United States Treasury. Therefore, they have various techniques to accept payment and what they need to do, or look for. When I do an accepted for value or accept for value, I make it deposited to, and make the self-created money order payable to the U.S. Treasury. I also endorse the back. Now if you look at taxpayer, it mentions personal check or money order. Is that a personal money order? We understand personal checks, but to my knowledge, accepted for value or accept for value, do we make a personal money order? However, let's us say that is incorrect. Then we must consider that they are to accept the money order, if it has been endorsed. Endorse is defined as, sign, a check or bill of exchange, on the back to make it payable to someone other than the stated payee or to accept responsibility for paying it. What check or money order do you endorse? Only if I wanted to cash it and that it is made out to me. So how does a check or money order get my endorsement? It is a personal money order, it needs to be endorsed by me, and this is in line with the accepted for value or accept for value. IRM, unacceptable payments. 1. Unacceptable payment of faxes are items that the depository bank will not accept. 3.8.45.4.9. Unacceptable payment of taxes are items that the depository bank will not accept as payment. Any of the following items found in the Payment Perfection Unit must be returned to the taxpayer using letter 2689, 2690, or 3270. Note, if these items are not returned immediately, they must be stored in a locked safe. Gold, silver, jewelry, stamps, savings bonds, treasury notes, treasury bills, stocks, treasury certificates of deposit, promissory note, gold coins, other than U.S. currency, deposit slips or withdrawal slips, credit card, S, debit card, S, gift card, S. Return the items of monetary value exceeding $10 by certified mail, and items under $10 by regular mail, within 24 hours of receipt. Process accompanying return/documents as non-remit. Credit cards for payment are not processed by the campus deposit function. Taxpayers may use a credit card to make payments towards balances owed by telephone. If you receive a taxpayer's credit card or correspondence with their credit card information in the mail, The deposit function will send the credit card back to the taxpayer through certified mail along with 3270 SC for return of credit card to taxpayers, advising the taxpayer that the IRS does not have the capability to process credit card payment transactions when the credit card or credit card information is submitted with the return or a return adjustment. Items of value that cannot be returned because the taxpayer cannot be identified, will not accept, or is undeliverable, should be maintained in a lock safe for the current year plus 3 years. If a claim for items being held is received from a taxpayer, return the item to the taxpayer as outlined in IRM 3.8.45.4.9, 2, above. If the taxpayer does not claim the item of value, the operations manager will determine the disposition of the item at the end of the retention period. These items will be recorded on form records of contents of safe/vaults. This form is currently available from your planning and analysis analyst. Managers will review this form monthly. As you see, gold and silver are first on the list. We are not to pay with gold and silver, we are to pay with self-created money order, personal money order that we endorse, accepted for value or accept for value. If the AFV is invalid, it would be returned. IRM 3.8.45.4.2, Remittance Perfection. Types of possible remittances the IRS campus may receive for processing can include any of the following: personal check, money order, cashier's check, cash, refer to cash clerks, business check, certified check, voucher check. 20. Treasure check, draft/postcard type check, gold coins, U.S. currency only, traveler's checks. Note, taxpayers may also pay taxes by credit card by phone. Types of taxes that can be paid by credit card are listed in IRM 21.2.1.50.4, credit or debit card payments, pay by phone or internet. Remittance perfection technicians may not process credit card payments to taxpayer accounts. Electronic funds transfer is another payment method. IRM March 8, 45 prescribes procedures for paper remittance processing. Keep remittance with source document, do not staple together. Prior to processing, remove check stubs and any staples attached. If payee is IRS only, cash, or blank, stamp United States Treasury on payee line. Money orders must have either the name of the taxpayer or TIN. If not present, enter taxpayer's TIN as it appears on the accompanying source document. When traveler's checks are received by mail, compare the counter signature with the original signature. If the signatures match, process the payment. When traveler's checks are received in person, walk-in customers on an exception basis witness countersigning and compare to the original signature on the traveler's check. If the traveler's check has only one signature, send it back to the taxpayer. If the signatures do not match, forward to your local TIGTA office. 6. When gold coins are received from a taxpayer, verify they are U.S. currency. If not U.S. currency, return to the taxpayer according to IRM 3.8.45.4.9. If U.S. currency, immediately contact the Property Appraisal and Liquidation (PAL) specialist at the telephone number shown below. The PAL will take possession of the coins so they can be sold at auction. SPC PAL specialist's phone no. Atlanta 706-650-3248, Austin 512-464-3097, Cincinnati 502-572-2284, Fresno 213-576-4380, Kansas City 816-503-4225, Ogden 503-326-3045. Gold coins must be stored in a locked safe until they are surrendered to the PAL. Voucher. Consider this as well, that when the IRS sends to us a presentment, they include a voucher or a coupon. Are not coupons a form of money or a reduction in the amount we pay? A coupon is also a form of a voucher. Look at this definition: coupon, noun, A voucher entitling the holder to a discount for a particular product, a detachable portion of a bond that is given up in return for a payment of interest. Notice above, voucher check. They are giving us the funds in which to settle the claim and we have been too ignorant to see it. We scream the IRS is taking too much. No. They have been trying to help us, but we would prefer to go to prison than give them back what they gave to us to settle the account out of complete ignorance. Render unto the IRS that which they created and get back to rendering unto God what God has given us. Our personal money orders are first issued and payable on demand. Title 31 3325. Vouchers. A disbursing official in the executive branch of the United States government shall 1. Disburse money only as provided by a voucher certified by a. the head of the executive agency concerned, or b. an officer or employee of the executive agency having written authorization from the head of the agency to certify vouchers. 2. Examine a voucher if necessary to decide if it is a. in proper form, b. certified and approved, and c. computed correctly on the facts certified, and 3. except for the correctness of computations on a voucher pursuant to payment intercepts or offsets pursuant to Section 3716 or 3720A of this Title I be held accountable for carrying out clauses 1 and 2 of this subsection. b. In addition to officers and employees referred to in subsection A. 1, b. of this section as having authorization to certify vouchers, members of the armed forces may certify vouchers when authorized, in writing, by the Secretary of 21. Defense or, in the case of the Coast Guard when it is not operating as a service in the Navy, by the Secretary of Homeland Security. c. On request, the Secretary of the Treasury may provide to the appropriate officer or employee of the United States government a list of persons receiving periodic payments from the government. When certified and in proper form, the list may be used as a voucher on which the Secretary may disburse money. d. The head of an executive agency or an officer or employee of an executive agency referred to in subsection A. 1, b. as applicable, shall include with each certified voucher submitted to a disbursing official pursuant to this section the taxpayer identifying number of each person to whom payment may be made under the voucher. UCC 3-501, a presentment means a demand made by or on behalf of a person entitled to enforce an instrument. I. To pay the instrument made to the drawee or a party obliged to pay the instrument or, in the case of a note or accepted draft payable at a bank, to the bank, or 2. To accept a draft made to the drawee. Above states, they can accept a voucher. Not a voucher along with a payment but the voucher. Are FRNs, checks, etc. i.e. money? Are they substance? They are a promise to pay, a promissory note, a debt instrument. Gold, silver, labor, are autographs, and land are substance. FRNs, checks, money orders, promissory notes, etc. are pieces of paper, fictions, and no substance, except if your real flesh and blood man/woman autograph in blue or purple ink happens to be on a money order, or in this case, a voucher. Notice, at the top of the dollars, FRNs, it belongs the Federal Reserve System. If I give you a promise to pay, whom do you collect from? Me. Can you offer it to another? No. How would I know if it is the original and not a forged IOU? If I agree to allow you to use it and they accept the promise to pay, then all is good. Just remember, if you use my promise to pay, what you bought with it, belongs to me. It is my name on the promise to pay, not yours. On the other hand, if I have it numbered, or a statement, this is legal tender for all debts, and have the government support for it, for public and private debts, then it will be accepted by everyone. UCC 3-105. A. Issue means the first delivery of an instrument by the maker or drawer, whether to a holder or non-holder, for the purpose of giving rights on the instrument to any person. b. An unissued instrument, or an unissued incomplete instrument that is completed, is binding on the maker or drawer, but non-issuance is a defense. An instrument that is conditionally issued or is issued for a special purpose is binding on the maker or drawer, but failure of the condition or special purpose to be fulfilled is a defense. C. Issuer applies to issued and unissued instruments and means a maker or drawer of an instrument. UCC 3-106, A. Except as provided in this section, for the purposes of Section 3-104, A. A promise or order is unconditional. These are payable on demand, UCC 3-104. Negotiable instrument. A. Except as provided in subsections C and D. Negotiable instrument means an unconditional promise or order to pay a fixed amount of money, with or without interest or other charges described in the promise or order, if it 1. Is payable to bearer or to order at the time it is issued or first comes into possession of a holder. 2. Is payable on demand or at a definite time, and 3. Does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money, but the promise or order may contain I. An undertaking or power to give, maintain, or protect collateral to secure payment. 2. An authorization or power to the holder to confess judgment or realize on or dispose of collateral, or 3. A waiver of the benefit of any law intended for the advantage or protection of an obliger. UCC 3-501. Presentment, B. The following rules are subject to Article 4, Agreement of the Parties, and Clearinghouse Rules and the like. 1. Presentment may be made at the place of payment of the instrument and must be made at the place of payment if the instrument is payable at a bank in the United States, may be made by any commercially reasonable means, including an oral, written, or electronic communication, is effective when the demand for payment or acceptance is received by the person to whom presentment is made, and is effective if made to any one of two or more makers, acceptors, drawees, or other payers. 2. Upon demand of the person to whom presentment is made, the person making presentment must I. Exhibit the instrument. 2. Give reasonable identification and, if presentment is made on behalf of another person, reasonable evidence of authority to do so, and 3. Sign a receipt on the instrument for any payment made or surrender the instrument if full payment is made. 3. Without dishonoring the instrument, the party to whom presentment is made may I. Return the instrument for lack of a necessary endorsement, or 2. Refuse payment or acceptance for failure of the presentment to comply with the terms of the instrument, an agreement of the parties, or other applicable law or rule. 22. 4. The party to whom presentment is made may treat presentment as occurring on the next business day after the day of presentment if the party to whom presentment is made has established a cut-off hour not earlier than 2 p.m. for the receipt and processing of instruments presented for payment or acceptance and presentment is made after the cut-off hour. UCC 4-105. Bank, depository bank, payer bank, intermediary bank, collecting bank, presenting bank. In this article, 1. Bank means a person engaged in the business of banking, including a savings bank, savings and loan association, credit union, or trust company. UCC 3-108, A. A promise or order is payable on demand and if it is refused, it is discharged. UCC 3-603, B. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge, to the extent of the amount of the tender, of the obligation of an indexer or accommodation party having a right of recourse with respect to the obligation to which the tender relates. We make them payable to the U.S. Treasury. UCC 3-110, C. A person to whom an instrument is payable may be identified in any way, including by name, identifying number, office, or account number. Honor their laws, in fact obey them when it comes to money. They put this down for us to use. Did I know I was a bank? Do servants tell their masters what they can and cannot do? Our God and King tells us he can do anything we ask. Our servants say we will settle all claims, all we have to do is tell them. Yet, we remain silent to God and to our servants. When will we learn? Worthless. With credit cards companies, the debt is theirs, as they gave us assurance that they would pay the debt, and they never do, for they cannot pay it with gold or silver. Therefore, the only value is by our own hand. What we can do is, accept for value, in spite of not having gold, or silver. When the people accept it for value, it becomes valuable. The people have spoken. Government is required to pay in gold or silver, people are not. However, if we are to do business with the government, then what we accept for value must be translated into an acceptable currency for the government to use. They exchange it, for what? I do not care. I am foreign to the government, as an American, and their money is considered worthless, illegal and void, as they are public servants, and create debt instruments. The only way the money has value is if the people have faith in it. It could be poker chips as far as anyone is concerned. How do I know FRNs are worthless? It says so in the IRS codes. Title 26 165, G, 2, C, this is where worthless securities are defined. G, worthless securities, 2, for purposes of this subsection, the term security means, c, a bond, debenture, note, or certificate, or other evidence of indebtedness, issued by a corporation or by a government or political subdivision thereof, with interest coupons or in registered form. Federal Reserve notes are evidence of a debt, an instrument registered, serial numbers, and created by a corporation. Anything that is not gold or silver from the government is evidence of indebtedness. Section G2C declares it a security of indebtedness and that it is worthless, in complete agreement with the 14th Amendment. For the validity of the public debt shall not be questioned, but all such debts, obligations, and claims shall be held illegal and void. If it comes from the people, it is a credit instrument, unless it is a promise to pay. There is so much more. I have included some important sections. Some believe accepted for value or accept for value is an offset or discharge. Personally, I do not care. They took the gold and silver, taxed me for using their money system that I am forced to use, not by choice. Let us review a few of these interesting sections. Such as Title 31 3701, A. In this chapter, 1. Administrative offset means withholding funds payable by the United States, including funds payable by the United States on behalf of a state government, 2. Or held by the United States for a person to satisfy a claim. Here are some other thoughts. If the government says they are spending taxpayer money, then they admit that the money is ours and not owed to the IRS. If it is owed, then it is not ours. If they borrow the money from the taxpayer, then how can the taxpayer pay a debt the government owes? The government has to pay it back to the people. The 14th Amendment claims they do not have to pay it. If I borrow money from you, how long will it take you to pay off the debt? Never. No worry, you cannot complain. Furthermore, they have no authority to borrow money from the taxpayer. The government can only borrow on the credit of the United States. Article 1, 8. To borrow money on the credit of the United States. Therefore, now we see why birth certificates are created. They needed vessels, thus property, U.S. citizens. Now they have collateral, something of value. If all money is a debt instrument, then the only way to pay off the national debt is to surrender all FRNs. No money would exist, and in fact, due to interests, fees, penalties, we would owe more than what exists. It would be invalid, as there is no way to pay the debt, and we would all be bankrupt. The law cannot demand an impossibility. However, this was true even when gold was being used. The only way to resolve this is by the use of foreign currency, and stuff made up by people, as people are foreign to governments. If I give it value and you accept it for value, then it exists as value, debts can be paid, or settled. This value created by the sovereign and accepted by other sovereigns, who are not bound by the law, will offset, or settle the debts of the government and make them go away. Government can only coin gold, people can write scripts, and have it given value by the U.S. Treasury to be used by the people in commerce. The government uses the private script to trade it for FRNs, it is not a part of the national debt. In essence, I created the FRNs when I create notes, or bonds. They may be debt instruments, however, it is backed by 23.
My private script has actual value. Does the government have the authority to settle claims? Let's look at their Bible, U.S. codes. Their scripture says, yeah, Title 31, subsection 3702. Authority to settle claims. B. 1. A claim against the government presented under this section must contain the signature and address of the claimant or the authorized representative. The claim must be received by the official responsible under subsection A for settling the claim or by the agency that conducts the activity from which the claim arises within 6 years after the claim accrues, except UCC subsection 3-603B. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge. To the extent of the amount of the lender or tender of the obligation of the endorser or accommodation party having a right of recourse with respect to the obligation to which the tender relates. Let's see. Signature, address of the claimant or authorized representative. If you know the verbiage of the A for V, accept it for value, or accept for value, this requirement is present. Address is included on their voucher. It has nothing to do with backed by gold, silver, bonds, or anything in fact. Feel free to correct me. Do they have a right to collect? Their mammon-based scripture says this. Title 31, subsection 3711. Collection and compromise. The head of the executive, judicial, or legislative agency 1. Shall try to collect a claim of the United States government for money or property arising out of the activities of or refer to the agency. G. 1. If a non-tax debt or claim owed to the United States has been delinquent for a period of 180 days, A. The head of the executive, judicial, or legislative agency that administers the program that gives rise to the debt or claim shall transfer the debt or claim to the Secretary of the Treasury, and B. Upon such transfer, the Secretary of the Treasury shall take the appropriate actions to collect or terminate collection actions on the debt or claim. 2. Paragraph 1 shall not apply to any debt or claim that I is in litigation or foreclosure. Claims and accounts. Are claims and accounts the same? Not really. Claims are what some think you owe them, where accounts are what you are responsible for. Therefore, there needs authority for settlement of accounts as well as claims. UCC subsection 3-601A. The obligation of a party to pay the instrument is discharged as stated in this article or by an act of agreement with the party which would discharge an obligation to pay money under a simple contract. Title 31, subsection 3526, Settlement of Accounts. The Comptroller General shall settle all claims, all accounts. Title 31, subsection 3526. Settlement of accounts. A. The Comptroller General shall settle all accounts of the United States government and supervise the recovery of all debts finally certified by the Comptroller General as due the government. B. A decision of the Comptroller General under Section 3529 of this title is conclusive on the Comptroller General when settling the account containing to the payment. C. 1. The Comptroller General shall settle an account of an accountable official within 3 years after the date the Comptroller General receives the account. A copy of the certificate of settlement shall be provided. The official shall be provided to the official. 2. The settlement of an account is conclusive on Comptroller General after 3 years after the account is received by the Comptroller General. However, an amount may be charged against the account after the third period when the government has or may have lost money because the official acted fraudulently, criminally. 3. A 3-year period under this subsection is suspended during a war. 4. This subsection does not prohibit a. Recovery of public money illegally or erroneously paid. B. Recovery from an official of a balance due the government under settlement within the 3-year period. Or C. An official from clearing an account of questioned items as prescribed by law. D. Unsettling the account of the government. D. Unsettling an account of the government. The balance certified by the Comptroller General is conclusive on the executive branch of the government. On the initiative of the Comptroller General or the request of an individual whose accounts are settled, or the head of the agency to which the account relates, the Comptroller General may change the account within a year after settlement. The decision of the Comptroller General to change the account is conclusive on the executive branch. E. When an amount of money is expended for law, for a treaty, or relations with a foreign country, the President may. 24. Authorize the amount to be accounted for each year specifically by settlement of the Comptroller General when the President decides the amount expended may be made public. Or 2. Make or have the Secretary of State make a certificate of the amount expended if the President decides the amount is not to be accounted for specifically. The certificate is a sufficient voucher for the amount stated in the certificate. F. The Comptroller General shall keep all settled accounts, vouchers, certificates, and related papers until they are disposed of as prescribed by law. G. This subchapter does not prohibit the Comptroller General from suspending an item in an account to get an additional evidence or explanations needed to settle an account.
Give permission. When we create the AFV and the money order, we are giving them permission for the Treasury Department to place our creation, i.e. AFV and MO, under the rules of foreign coin, weights, and measures, as established by Congress, Article 1, 8, to coin money, regulate the value thereof, and of foreign coin, and fix the standard of weights and measures. Our creations are foreign to the government and even more so to the democracy, but it also foreign to everyone else, as theirs is to every one of us non-government employees. Therefore, once we accepted the presentment/statement/bill for value, they are to release the funds. Their scripture allows for this as well. Consider that funds are not money, may not even be FRNs, or even circulating notes. Funds are defined as a sum of money saved or made available for a particular purpose, financial resources, a large stock or supply of something, or an organization set up for the administration and management of a monetary fund. UCC 3 to 602, a. Subject to subsection, b. An instrument is paid to the extent payment is made, I, by or on behalf of a party obliged to pay the instrument, and 2. To a person entitled to enforce the instrument. To the extent of the payment, the obligation of the party obliged to pay the instrument is discharged even though payment is made with knowledge of a claim to the instrument under Section 3 to 306 by another person. The Treasury has an obligation, public trust, as a department of government serving the public, people, interest to the bank with a member of the Federal Reserve System that has a commercial obligation to an account holder and a third party who tendered the item in payment to tell them that it's not any good or it's not going to be honored, even if they wanted to keep it for prosecution or investigation. This is in effect what the directive says the government will do if it's no good. Public, of or concerning the people as a whole, open to or shared by all the people of an area or country, ordinary people in general, the community, in public in view of other people, origin Late Middle English, from Old French, from Latin publicus, blend of populus of the people, from populus people, and pubes adult. They do not dishonor it in any way by return of the item or the sending of any notice to that effect, or make request for additional information or time for examination of the instrument, or given a statement of explanation indicating the time frame for its review and settlement if it would be an inordinately lengthy time as longer than 60 days to finish with it. The instruments are being kept, held, and without return or dishonor, are accepted as an obligation of the United States in the discharge and recovery of the public debt as it makes claim on its face to be. Put another way, if the bank had had to pay the item to honor its customer agreement as if it had been a check, what would or could the bank be trying to do with it to finally settle the account? The bank needs to treat the instrument tendered as an obligation of the United States to the bank. The tender of these instruments discharge the obligation of the debt for which they are delivered, and the payee becomes the new holder in due course and collection agent on the instruments. Title 31 3335, Timely Disbursement of Federal Funds. A. Each head of an executive agency, other than the Tennessee Valley Authority, shall, under such regulations as the Secretary of the Treasury shall prescribe, provide for the timely disbursement of federal funds through cash, checks, electronic funds transfer, or any other means identified by the Secretary. B. The Secretary may collect from any executive agency which does not comply with subsection A. A charge in an amount the Secretary determines to be the cost to the general fund of the Treasury caused by such non-compliance. C. The amounts of charges collected from an executive agency under this section shall be deposited in the Treasury and credited as miscellaneous receipts. D. Any charge assessed by the Secretary under this section, to the maximum extent practicable, 1. Shall be paid out of appropriations available for executive agency operations, and 2. Shall not be paid from amounts available for funding programs of an executive agency. Commerce. Concerning commerce and the exchange of goods by the Law Book 1 Chapter X 109, of exchange, and the laws of commerce, there is another custom more modern, and of no less use to commerce than the establishment of coin, namely exchange, or the traffic of bankers, by means of which a merchant remits immense sums from one end of the world to the other, at a very trifling expense, and, if he pleases, without risk. For the same reason that sovereigns are obliged to protect commerce, they 25. Authorize the amount, are obliged to support this custom, by good laws, in which every merchant, whether citizen or foreigner, may find security. In general, it is equally the interest and the duty of every nation to have wise and equitable commercial laws established in the country. 49. The modern law of nations, and the municipal law of England, as to coin, bullion, and money, will be found collected in one blat. Com 276 to 280, 4 ID 84 to 120, 1 Chitty's Commercial Law, 583, 2 ID 179 to 187, and statutes and decisions there collected. C. 1. In Boisard's treatise on coin, we find the following observations. It is worthy of remark, that, when our kings debased the coin, they kept the circumstance a secret from the people, witness the ordinance of Philip de Valois in 1350, by which he ordered Tournois doubles to be coined 2d5 and 1/3 gr fine, which was, in fact, a debasement of the coin. In that ordinance, addressing the officers of the mint, he says, upon the oath by which you are bound to the king, keep this affair as secret as you possibly can, that neither the bankers nor others may, by your means, acquire any knowledge of it, for if, through you, it comes to be known, you shall be punished for the offense in such manner as shall serve as an example to others. The same author quotes other similar ordinances of the same king, and one issued by the Dauphin, who governed the kingdom as regent during the captivity of King John, dated June 27, 1360, by virtue of which the mint masters, directing the officers engaged in the coinage to coin white deniers 1d. 12 gr fine, at the same time expressly command them to keep this order secret, and, if any persons should make inquiry respecting their standard, to maintain that they were 2d fine. Chap XXIX. The kings of France had recourse to this strange expedient in cases of urgent necessity, but they saw its injustice. The same author, speaking of the debasement of coin, or the various modes of reducing its intrinsic value, says these expedients are but rarely resorted to, because they give occasion to the exportation or melting down of the good specie, and to the introduction and circulation of foreign coin raise the price of everything, impoverish individuals, diminish the revenue, which is paid in specie of inferior value, and sometimes put a total stop to commerce. This truth has been so well understood in all ages, that those princes who had recourse to one or other of these modes of debasing the coin in difficult times, ceased to practice it the moment the necessity ceased to exist. We have, on this subject, an ordinance of Philip the Fair, issued in May, 1295, which announces, that, the king having reduced the coin both in fineness and weight, and expecting to be obliged to make a further reduction in order to retrieve his affairs, but knowing himself to be, in conscience, responsible for the injury caused to the state by such reduction, pledges himself to the people of his kingdom, by solemn charter, that, as soon as his affairs are retrieved, he will restore the coin to its proper standard and value, at his own private cost and expense, and will himself bear all the loss and waste. And, in addition to this engagement, Dame Joan, Queen of France and Navarre, pledges her revenues and dower for the same purpose. Note. Edit AD 1797. 2. In his Republic, Book I, Chapter X, 50, this is a sound principle, which ought to be extended so as to deny effect to any fraud upon a foreign nation or its subjects. But in England, a narrow and immoral policy prevails of not noticing frauds upon the revenue of a foreign state. Roche v. Eady, 6th Term Republic 425, Boucher v. Lawrence, R.T. Hard. 198, Holman v. Johnson, Cowp. 343, James v. Catherwood, 3 Dowell. And R.Y.L. 190, Cambioisos ex v. Maffets Assignees, 2 Wash, CC Republic 99. And so far has this narrow doctrine been carried, in disgrace of this country, that, in Smith v. Marconi, 2 Peaks Republic 81, it was held, that the maker of paper in England, knowingly made by him for the purpose of forging assignats upon the same, to be exported to France in order to commit frauds there on other persons, might recover damages for not accepting such paper pursuant to contract. So a master of an English ship was even allowed to recover salvage for bringing home his captured vessel, by deceptively inducing the enemy to release the vessel on his giving a ransom bill, payment of which he looked care to countermand in London. 2 Dodsons are 74. So restated, according to, Lawn Book 1 Chapter X 106, as referenced in, Article 185, Constitution for the United States of America. Money is fabricated or invented by the power or right to control and in behalf of, on the part of, by authority of the state or any sovereign, who are its surety. Therefore, money is meaningless, as it is made up. Gold and silver only have value because we have declared it has value. Whatever we give value to, has value, at least to us, accepted for value or except for value. Congress is to punish those that have committed offenses against the law of nations. Article 1810. Notice how this section also includes high seas crimes, control of vessels, and U.S. citizens are vessels. Matthew 9-15. Our Father which art in heaven, hallowed be thy name. Thy kingdom come. Thy will be done in earth, as it is in heaven. Give us this day our daily bread. And forgive us our debts, as we forgive our debtors. And lead us not into temptation, but deliver us from evil, for thine is the kingdom, and the power, and the glory, forever. Amen. For if ye forgive men their trespasses, your heavenly Father will also forgive you, but if ye forgive not men their trespasses, neither will your Father forgive your trespasses. Will we use gold to buy things when in heaven? Using money is in violation of God's will. Yet using money is what we do to survive on earth, at least until the men of the governments in the earth, the dead, of which corporations are, decide they too want to follow God. Money does not make us good nor evil, it only is a magnifier as to who we already are. When we have money for the sake of money or in fear of scarcity, then money rules. When we have money for how we can use it to help others, then we are doing good towards our fellow man. Money does nothing but demonstrates our talents. How much talent do you have? Can we barter? Trade? Exchange items? Can we do this all on paper? As old as time. We now know that there are laws that allow us to do this accepted for value or except for value, as wealth, mammon, is made up, which means poverty is a lie. Is there a biblical reference to this acceptance and discharge? It is all over the 26. Are obliged to support Bible. As for Christians, it is the foundation of its existence, and the crucifixion. Luke 23:32 and 2 others, evildoers, were taken with him to be put to death. 33 And when they came to the place which is named Golgotha, they put him on the cross, and the evildoers, one on the right side, and the other on the left. Luke 23:39-43 And one of the evildoers on the cross, with bitter feeling, said to him, Are you not the Christ? Get yourself and us out of this. But the other, protesting, said, Have you no fear of God? For you have a part in the same punishment, and with reason, for we have the right reward of our acts, but this man has done nothing wrong. And he said, Jesus, keep me in mind when you come in your kingdom. And he said to him, Truly I say to you, today you will be with me in paradise. Was this man baptized? No indication that he was. Also note they specially mention the left and right. Where in our glorious accounting system do we put debts? Debts go on the left side and the credits go on the right. In the middle is the cross of accounting, or 0 point. What did this man do? He accepted for value his punishment and he was granted paradise. His debts/sins were forgiven. Ever since the garden, be it fantasy, fiction, or reality, it tells of the value of not accepting your debts, actions. Genesis 2:9-14 And the voice of the Lord God came to the man, saying, Where are you? And he said, Hearing your voice in the garden I was full of fear, because I was without clothing, and I kept myself from your eyes. And he said, Who gave you the knowledge that you were without clothing? Have you taken of the fruit of the tree which I said you were not to take? And the man said, The woman whom you gave to be with me, she gave me the fruit of the tree and I took it. And the Lord God said to the woman, What have you done? And the woman said, I was tricked by the deceit of the snake and I took it. And the Lord God said to the snake, Because you have done this you are cursed more than all cattle and every beast of the field, you will go flat on the earth, and dust will be your food all the days of your life. Did these two accept their actions? No. They decided to hide. One cannot be forgiven, if one does not admit or accept. As if God did not know what happened? Did God argue?
Nope.
Debate? Discuss? Challenge? On the other hand, did God accept their answers and punish whom they blamed? God in fact did unto Adam and Eve as he would have wanted done to him, and that is accept the words as spoken, even if it were a lie. The snake was never asked why he did it, never given the opportunity to blame anyone or make up a story, never had the opportunity to seek forgiveness. What would have happened had Adam said, "It is my fault for our actions, please forgive me"? Nevertheless, we spend our life judging and blaming others for our actions. The fruit of tree of knowledge of good and evil is all about judgment. The fruit is symbolic for you reap what you sow. The fruit of the actions, results. Knowledge is experience. Good and evil is judgment. This earthly reality is the result of experiencing judgment. Paradise lost, it is hell. When God killed King David's son, it was due to David's own decree. He had committed adultery and murder to get Bathsheba. David accepted for value his sins. Christ is often referred to as the Son of David, for a son will be the price for the sins of others. In addition, if we go further into the Bible, does it not say, "Agree with thine adversary quickly"? Matthew 5:25, Matthew 5:40. And if any man will sue thee at the law, and take away thy coat, let him have thy cloak also. Know that when you disagree with another, you call him a liar or at least dishonor. This is why it is important to countersue, rather than being a defendant, for a defendant position is to claim the other has lied, and if you cannot prove it, you become the liar, you would be in dishonor. If I say this is black and another says this is white, one is lying. They may in fact view it differently than I, but this is not the claim. I see this as being white. Whom am I to say what he understands is incorrect? Stop pointing fingers and accept for value the way they see it. It does not mean it is true, it only means this is what they believe. Does government lie? It is a fiction. What else can fictions do but create fictions? A fiction is a lie. There are also other principles as well. Do unto others as you have them do unto you. Judge not lest you be judged. Turn the other cheek. Forgive and ye will be forgiven. Do these conflict with the idea of accept for value? Are they not in line with accepted for value or accept for value? Love your neighbor as thyself. Love God with all your heart, mind, body, and spirit. How can you love, if you are calling them a liar, or fighting with them? Tender. UCC 3-302, A subject to subsection, C, and section 3-106, D. Holder in due course means the holder of an instrument. UCC 4-211, for purposes of determining its status as a holder in due course, a bank has given value to the extent it has a security interest in an item, if the bank otherwise complies with the requirements of section 3-302 on what constitutes a holder in due course. We are banks. UCC 3-203, C. Unless otherwise agreed, if an instrument is transferred for value and the transferee does not become a holder because of lack of endorsement by the transferor, the transferee has a specifically enforceable right to the unqualified endorsement of the transferor, but negotiation of the instrument does not occur until the endorsement is made. UCC 4-210. A collecting bank has a security interest in an item and any accompanying documents or the proceeds of either. 2. In case of an item for which it has given credit available for withdrawal as of right, to the extent of the credit given, whether or not the credit is drawn upon or there is a right of chargeback. C. Receipt by a collecting bank of a final settlement for an item is a realization on its security interest in the item, accompanying documents, and proceeds. So long as the bank does not receive final settlement for the item or give up possession of the item or possession or control of the accompanying documents for purposes other than collection, the security interest continues to that extent and is subject to Article 9, Secured Transactions. 27. Bible, as for Christians, it is the foundation of its existence, and the crucifixion, Luke 23:32, and 2 others, evildoers, were taken with him to be put to death. 33. And when they came to the place which is named Golgotha, they put him on the cross, and the evildoers, one on the right side, and the other on the left. Luke 23:39-43. And one of the evildoers on the cross, with bitter feeling, said to him, "Are you not the Christ? Get yourself and us out of this." But the other, protesting, said, "Have you no fear of God? For you have a part in the same punishment, and with reason, for we have the right reward of our acts, but this man has done nothing wrong." And he said, "Jesus, keep me in mind when you come in your kingdom." And he said to him, "Truly I say to you, today you will be with me in paradise." Was this man baptized? No indication that he was. Also note they specially mention the left and right. Where in our glorious accounting system do we put debts? Debts go on the left side and the credits go on the right. In the middle is the cross of accounting, or 0 point. What did this man do? He accepted for value his punishment. UCC 3-303. Bible, UCC 3-303. A. An instrument is issued or transferred for value if 1. The instrument is issued or transferred for a promise of performance, to the extent the promise has been performed. 3. The instrument is issued or transferred as payment of, or as security for, an antecedent claim against any person, whether or not the claim is due. 4. The instrument is issued or transferred in exchange for a negotiable instrument, or 5. The instrument is issued or transferred in exchange for the incurring of an irrevocable obligation to a third party by the person taking the instrument. B. Consideration means any consideration sufficient to support a simple contract. The drawer or maker of an instrument has a defense if the instrument is issued without consideration. If an instrument is issued for a promise of performance, the issuer has a defense to the extent performance of the promise is due and the promise has not been performed. If an instrument is issued for value as stated in subsection A, the instrument is also issued for consideration. Title 12 371b2, c. 1, for purposes of subsection B, of this section, an insured depository institution's exposure to another depository institution means A. All extensions of credit to the other depository institution, regardless of name or description, including I. All deposits at the other depository institution. 2. All purchases of securities or other assets from the other depository institution subject to an agreement to repurchase, and 3. All guarantees, acceptances, or letters of credit, including endorsements or standby letters of credit, on behalf of the other depository institution. B. All purchases of or investments in securities issued by the other depository institution. C. All securities issued by the other depository institution accepted as collateral for an extension of credit to any person, and D. All similar transactions that the board by regulation determines to be exposure for purposes of this section. UCC 3-603. Tender of payment. A. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, the effect of tender is governed by principles of law applicable to tender of payment under a simple contract. B. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge, to the extent of the amount of the tender, of the obligation of an indexer or accommodation party having a right of recourse with respect to the obligation to which the tender relates. C. If tender of payment of an amount due on an instrument is made to a person entitled to enforce the instrument, the obligation of the obliger to pay interest after the due date on the amount tendered is discharged. If presentment is required with respect to an instrument and the obliger is able and ready to pay on the due date at every place of payment stated in the instrument, the obliger is deemed to have made tender of payment on the due date to the person entitled to enforce the instrument. Sinful. Except for veil has its roots as old as man. How did one use to settle sins? They used goats, by placing their hands upon the animal and passed their debts onto, or into the goat, and set it free, or slit its throat. By our acceptance, and by our hand we charge the vehicle to settle our debts. Is this not what we do for the except for value, as an alleged Christian? How have people claimed to have healed the sick, pass on blessings, pass on sins, give firstborn rights, perform marriages, pray, cast spells, build, farm or many other things? It is all done by hand. Hands are a source of passion, strength, creation, and spirituality. It is by our own hands that we give value, accept gifts, present gifts. Hands have power. There is the doctrine of clean hands, or doctrine of unclean hands. We greet, hug, fight, salute, talk, and a lot more, by our hands. It is our energy. UCC 4-213. A. With respect to settlement by a bank, the medium and time of settlement may be prescribed by Federal Reserve regulations or circulars, clearinghouse rules, and the like, or agreement. In the absence of such prescription, 1. The medium of settlement is cash or credit to an account in a Federal Reserve Bank of or specified by the person to receive settlement, and 2. The time of settlement is 2. With respect to tender of settlement by credit in an account in a Federal Reserve Bank, when the credit is made. D. If settlement for an item is made by giving authority to charge the account of the bank giving settlement in the bank receiving settlement, settlement is final when the charge is made by the bank receiving settlement if there are funds available in the account for the amount of the item. 28. It is not by payment, it is by settlement, funds are released or converted. The recovery remedy is maintained in law because it has to be to satisfy equity to its prime creditors. Nevertheless, at this late time, the United States is neither expecting nor intending it to be generally accessed by those in responsibility will not deny or dishonor it, or an instrument of discharge properly submitted for that purpose. No agency has ever returned my accepted for value presentments back to me as refused. Conclusion. The United States, a private for-profit federal corporation, is bankrupt and has to pay our bills. The substance of the American citizenry, their real property, wealth, assets, and productivity that belongs to them, was pledged by the government and placed at risk as the collateral for U.S. debt, credit, and currency for commerce to function. Under the 14th Amendment and numerous Supreme Court precedents, as well as in equity, private property cannot be taken or pledged for public use without just compensation. United States v. Russell, 13 Wall, 623, 627, or due process of law. The United States cannot pledge or risk the property and wealth of its private citizens for any government purpose without legally providing them remedy to recover what is due them on their risk. Courts have long ruled that to have one's property legally held as collateral or surety for a debt, even when one still owns it and still has it, is to deprive him of it since it is at risk and could be lost for the debt at any time. Sureties compelled to pay debts for their principal have been deemed entitled to reimbursement, even without a contractual promise. And probably there are few doctrines better established. Perlman v. Reliance Insco, 371 U.S. 132, 1962. Those backing the nation's credit and currency cannot recover what is due them by anything drawn on Federal Reserve notes without expanding their risk and obligation to their own selves. Any recovery payments backed by this currency, FRNs or Federal Reserve Accounting Unit devices, frauds, would only increase the public debt its citizens are collateral for, which an equitable remedy was intended to reduce, and inequity would not satisfy anything, for there was no longer actual money of substance to pay anybody. In other words, there is no actual money in circulation by which debt owed from one party to another can actually be repaid. Since 1933, no one has ever really been paid because there has been no money of substance. Every time we spend $1, IOU, we increase the national debt by that same amount. Every time we send our bills to Treasury for the set-off, we reduce the national debt by that same amount. Federal Reserve publication Public Debt, Private Asset says the national debt is owed to its creditors, which is you and I. We are operating under official public policy set forth by the United States when they confiscated all the lawful money in circulation in 1933, and it became impossible to pay any debts with publicly sanctioned money under the provision of the United States Constitution, Article 1, Section 10, Clause 1. In return for the confiscation of the lawful money, the United States became liable to pay the debts of the people as fiduciary creditors, agents, of the people. Since all commercial energy in existence comes from the mental and physical powers of the living people, and not from corporations or government, these living people are the lenders or creditors to all of society. Government cannot have a binding contract on you based on the rule of valuable consideration because everything government has came from you to begin with. Therefore, no adhesion contract that identifies you as a public employee could be binding upon you. They cannot prove they ever loaned us anything. This can be proven with a validation of debt, which they never will, or can, validate, verify or answer to our satisfaction. A copy of the payments you made is not validation of a debt owed. It does tell you how much to sue them for to get your payments back and add that to the original amount of your credit they borrowed when you took out a car or house loan. When they do not answer you by your deadline, you default them and can present copies of those letters to the court, and collect double or triple damages. Publicly, judges and politicians will not admit to this because of the chaos they believe will occur, and that we probably would hang them for wasting our lives in meaningless jobs, when they were supposed to be setting off our bills. The government needed to account for how much commercial energy it owed each and every one of us, the ultimate creditors, for our contribution. The creation of the SSN accounts allowed the government to take our commercial energy and use it to keep the nation's economy moving forward in the bankruptcy, while at the same time not being guilty of fraud or theft. Therefore, the SSN is to track our claims against the United States. We are the creditors and they are the debtors. Therefore, we have a prepaid account with the United States since we are the creditors and it is the debtor. The CAFR accounting is the summary results of this accounting of keeping track of the people's contributions and earnings on those contributions and is currently estimated at $60 to $100 trillion. Accepted for value applies when a demand is made for payment with implied consideration. If there is no original wet ink signed contract where both parties offer consideration, then there is no demand possible, only demand W/implied consideration, which, according to UCC, holds inherent risk to the issuer. If the instrument is accepted as consideration, and returned for value, the issuer is liable for the bill. That is where the payment comes from. In the bankruptcy, whoever brings a liability has to bring the remedy. Whoever hands you a bill has to hand you the check to pay it. Write the accepted for value verbiage on the statement, write a private issue money order on the coupon part of the bill, and send it to Treasury to have it set off. The only way that utility company was built is that they mortgaged, borrowed against, our property and future labor compensation, so everything since 1933 is prepaid. A true contract has consideration from both parties. Consideration occurs when the bank, credit card company, whoever, has actually offered you something and you offered to pay them back. Of course, we know the banks, credit card companies, whoever, do not actually loan us anything. They use our signature to get funds, our own credit, from Treasury. 29. To deny AFV, is to claim sins will not be forgiven, by God, in earth, as it is in heaven. What you bind on earth will be bound in heaven. Given in love to the children of God, my brothers and sisters. Knock and the door will open, seek and you will find, and ask and it will be given. Remember, if you have faith, without doubting, not only may you do what has been done, but even if you say to this mountain, be taken up and put into the sea, it will be done. Matthew 21:21. Agree with thine adversary quickly, while thou art in the way with him, lest at any time the adversary deliver thee to the judge, and the judge deliver thee to the officer, and thou be cast into prison. Verily I say unto thee, thou shalt by no means come out thence, till thou hast paid the uttermost farthing. Matthew 5:25-26. Render unto Caesar what is Caesar's. How was that determined? The coin, whose face is on it? The dead are on our FRNs. The dead use it, the dead accept it, the dead create it. Whose name is on the FRNs? Federal Reserve. Thus if the IRS, acting in behalf of the Federal Reserve System demands funds, give it to them. Accept the demand, request, or the pleading. Be in honor with their laws, codes, statutes, appease the beast with feet of clay, do not argue with the Antichrist AFV it. You can accept or reject AFV and you will be right. Why? I cannot prove the world is round until you're willing to accept the idea that it might be and willing to understand. If you reject the idea, who am I to say you are wrong? I will not dishonor your beliefs. I have given you facts and information that you can check out, correct me if or where I am wrong, or ignore it. Do words have meaning? Do words have value? If words mean nothing, if words mean something, what is it? You decide, if accepted for value or accept for value is a valid process. Is the Federal Reserve Note, FRN, real money? Are the Federal Reserve System and the democracy considered false coiners? If you say no, you are right. After all, why would I argue with you? You are creator of fictions. A fiction is a non-truth, which could be a lie if it were to deceive you. If you believe it was designed to deceive, then consider, who is the father of lies? I would then have to say, I see it differently. If you put God first, then all these things will be added to you. God can touch man, and man can reach out to God. Man can never touch a corporation, nor can any corporation reach out to man. It is an artificial entity, a fiction, a name we call a thing, soulless, lifeless, emotionless, and thoughtless. It needs actors and puppeteers. It is only business. The art of business is to benefit man, a vehicle to help others in a group setting. Man needs to give, to live. Corporations only express their master's desires. May they be deserving desires. In the name of the King, of the kingdom of heaven, it is done.